Santa Maria hearing room. Would you call the roll, Ms. Alexander?
Mr. Adam?
Here.
Mr. Lavanino?
Here.
Mr. Williams? Ms. Wolf?
Here.
Ms. Hartman?
Here. Please stand for the pledge. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May I have a motion to approve the minutes of September 12th, 2017?
So moved.
A second?
Second.
All in favor say aye. Aye. Any opposed? Minutes stand approved. Do we have a CEO's report today, Ms. Miyasato?
Nothing this morning, Chair.
Okay. I'd like to make an announcement about a slight change in our departmental agenda. We're going to hear the item number, the cannabis item after lunch rather than before lunch and when we break for our closed session. So turning to our administrative agenda, we have one honorary resolution, A30. Would you read that into the record, Ms. Alexander? Yeah, well, we can have our motion before or after. May I have a motion to approve? Second? All in favor?
Aye.
Okay, now read it into the record.
Chair Hartman,
Madam
members
Chair,
of the board.
I'm sorry, just agenda management. So it would be helpful, I think, that, I know it's really difficult when we're scheduling things and this, but when we have an item that we're going to have this many people for, and I know I have a lot of constituents that were interested in that item, if we know, the sooner we know it's going to be after lunch. I don't know if we just figured that out just now.
I thought there was some information
Was
that
there?
went out to people that it would be after
Okay.
lunch, but I may not have
Okay,
gotten
maybe
it
I
as
missed it,
broadly.
but if I would have gotten it, I would have, I just want to let folks know that I would have got that information out, so the sooner we know, the better, I guess.
Chair Hartman, Supervisor Loving, we did in our bulletin announcements out to our pretty broad array of folks, we did notice that the agenda might be switched slightly this week because of the length of the one item, so.
Thank you.
All right. So we're ready to read that. No, I'm glad you brought it up, and we thought we could better accommodate the public if we did that after lunch, and we expect that maybe it'll be 1 or 1:30. Ms. Alexander.
Chair Hartman and members of the board, administrative item number 30 is sponsored by Supervisor Hartman and Supervisor Lavanino. It is to adopt a resolution proclaiming the week of September 17th, 2017 through September 23rd, 2017 as Child Passenger Safety Week in Santa Barbara County. And if I can have Teresa Jones from the First 5 Program Officer, Lieutenant Aaron York, Santa Maria CHP Area Commander, and Danny Mayer, CHP Coastal Division Public Information Officer, come to the podium. And anyone else you would like to join you, that would be great. And I'll go ahead and read the resolution. Whereas the number one preventable cause of death and injury of children is the automobile collision, and whereas car seat use reduces the risk for death to infants by 71% and to toddlers aged 1 through 4 years by 54%, and whereas the use of booster seat for children 4 to 8 years of age reduces the risk of serious injury by 45%, and whereas 9 out of 10 car seats are installed improperly, and if used correctly, car seats can dramatically reduce the risk of serious and fatal injuries, making these statistics preventable. Whereas the state of California requires all occupants of a motor vehicle to be properly secured, and children less than 8 years of age be secured in an appropriate child seat, remaining in the back seat until at least 13 years of age. Now, therefore, be it resolved and ordered that the Board of Supervisors of the County of Santa Barbara, State of California, does hereby proclaim September 17th through the 23rd, 2017 as Child Passenger Safety Week in Santa Barbara County, and encourages all residents to support and participate in child passenger safety activities. Passed and adopted today.
Madam Chair, may we say a few words?
Please, yes.
I just wanted to thank the Board of Supervisors, in particular you and Supervisor Lavanino, for supporting this important topic, and I'm going to turn it over to Lieutenant York to say a few words.
Madam Chair and fellow board members, thank you for your steadfast support in this very important life-saving effort. And to our friends from First Five of Santa Barbara County, thank you for the ongoing collaboration and partnership that we enjoy. You heard the statistics today. Fortunately, in Santa Barbara County, we've come a long way in making sure that we reach our goal of ensuring every child is properly restrained every time they ride in a vehicle. Yet there's more work to be done. And it's only through the continued collaboration and continued combined efforts of the CHP, our partners in public safety in the community, as well as parents and caregivers, that we're going to continue to be successful in driving down the preventable occurrence of injuries and fatalities to the children in our community. Thank you for your support in this effort, and thank you for bringing additional awareness to this important life-saving mission.
And may I ask a question? Are there programs, one to get car seats and another to teach people how to use them?
There absolutely are. We have a slew of trained technicians. Officer Mayer here is one of our spearhead point people for that effort in our division. And we have programs to help get proper car seats for folks that have deficient car seats. So we have an exchange opportunity, and we have a multitude of community efforts throughout the county to help open up awareness, bring parents and children in to have their cars inspected at all of our CHP offices. And we partnered recently with organizations such as Marion Medical Center to help bring that information out in a broader way to the community.
And is there a website or where people can get the information?
Yes, ma'am. There's plenty of websites out there. The Highway Patrol, when we train our new technicians, they're all trained through safekids.org, which is a great website to go to. They can also go to the National Highway Traffic Safety Administration, or even to the Highway Patrol, to our websites, to find out locations for every office where there is a technician available.
Good, thank you. Supervisor Wolf.
Thank you, Madam Chair. Speaking on behalf of grandparents, you know, this is all new kind of stuff for us. We used to just get the car seat, put it in, and put the kids in, and it's much more involved right now, and it is for the safety of our kids. But I just really appreciate everything that you folks are doing, and just for people out there. We went to the fire station and had them put the car seat in. And I think you mentioned all public safety, which I really appreciate, because they are really the experts in this, and it is more complicated than it was, 35 years ago, 40
sure.
years ago. So,
Yes, ma'am.
thank you.
You bet.
Thank you.
Thank you.
Ms. Alexander, did you have some announcements about our agenda?
Yes, Chair Hartman and members of the board, we posted an addendum on Friday amending 2 items on today's agenda. The first item was amending the recommendations on item A23 from Public Works to consider recommendations regarding a real property exchange agreement, quitclaim deed, permanent easement deed, and First Amendment to 1955 easement agreement for the relocation of a storm drain easement at 155 East Clark Avenue, Orchid, in the 4th District. And the second item on our agenda was amending the file number for item A29 from Planning and Development. It was a set hearing to consider recommendations regarding a short-term rental ordinance for October 3rd, 2017 in Santa Barbara.
Okay, thank you. I have 2 items that supervisors have pulled, number A11 and A16. Are there any others? So would you read A11 into the record, Ms. Alexander?
Chair Hartman and members of the board, item A11 is from County Council. It is to consider recommendations regarding the reappointment and employment contract for the County Executive Officer.
Mr. Gazzoni?
Chair Hartman and Supervisors, there's a new Brown Act requirement that has me summarize the compensation and benefits in this executive contract. And within the board agenda letter and for your employment contract, they state an annual salary of $259,472, which is a performance-based increase of 4%. And as with other county managers, payment for health and dental plans of about $380 per pay period. As with other county managers, a benefit allowance of about $249 per pay period, a car allowance, and retirement benefits, including a 401A contribution of $5,000. And that is a new requirement effective in 2017, if people are wondering why we're doing this.
Thank you. And do we have any public speaker slips on this item?
Chair Hartman and members of the board, we have no requests to speak from the public on this item.
Okay, may I have a motion and a second?
I'll move this item.
Second.
Would anyone like to say anything in addition? Could I have a roll call vote?
Mr. Adam?
Aye.
Mr. Lavanino?
Aye.
Mr. Williams?
Aye.
Ms. Wolf?
Aye.
Ms. Hartman?
Aye.
Motion passes.
And A16 into the record, please.
Chair Hartman and members of the board, item A16 is from General Services. It is to consider recommendations regarding a Sweepy LP Guadalupe Dunes lease termination agreement in the 3rd District.
Supervisor Adam.
Yeah, I just want to point out the hypocrisy in this item. We're going to be taking money in exchange for not enforcing mitigations, which were agreed to begin with. And I would just wanted to make the observation that it's been estimated that it would cost this oil company $6 million to do what we're going to give them for $3 million. So that's you know, and that this wouldn't be available to any other business in Santa Barbara County. So I don't know what exactly is going on here, but somehow it seems to be happening.
Supervisor Williams?
I'd just say that regardless of the decisions made by previous boards and previous staff in the county on required mitigations, that what we have before us is a simple question of would this parcel be better for the community and better for the environment held in public trust without ripping up the whole thing. And the call of the experts out there is because some of the stuff is buried, that it would be better as a public resource. Obviously not something that people would be living on, but as a public resource, perhaps someplace you can visit. It's got a relatively thriving ecology, and it's adjacent to other public land that's used by local people. So I think we just have a question, regardless of the decisions made before, of whether to pounce on this opportunity or not, and I think we should do it for the benefit of Ms. Hartman's constituents.
Thank you. I have visited the site, and there is a lot of gravel from the roads that Shell used for its oil platforms. That gravel is in the dunes and has been there for decades now, and many plants have taken root around it, and it would be a major environmental destruction to pull all of that out to try to take each of the little sand gravel pieces out. So I think the mitigation is putting that money into acquiring other land and creating more opportunities, especially here in North County, is a very worthwhile thing to do. Would you like a vote, Supervisor Adam, on this item? Roll call vote. Okay. So
I'd like to say first, Madam Chair, that I agree with you in principle, Supervisor Adam, that I hope that we look at all of these that come before us, not just one that benefits the county, but all of these. But on this particular one, I just think it would be practically impossible to do the mitigation that's required, and we should probably always look at whether or not it makes sense to move forward with something that a previous board placed on a project. So
Supervisor Williams, would you be willing to make a motion?
I'll move the acquisition.
And I second. And would you call the vote?
Chair Hartman
Yes.
and Supervisors, I'm just clarifying that the motion is actually, at this stage, is a lease termination agreement, and I would recommend just moving staff's recommendations.
Yes.
Absolutely. I'll move staff recommendation for the termination of the lease agreement.
So we have a motion and a second, and we'll call the roll.
Mr. Adam?
No.
Mr. Lavanino?
Aye.
Mr. Williams?
Aye.
Ms. Wolf?
Aye.
Ms. Hartman?
Aye.
Motion passes 4-1.
And Supervisor Wolf would like to pull item number 12. Would you read that into the record?
Chair Hartman and members of the board, item A12 is from the County Executive Office. It is to approve budget revision requests, and there is a 4/5 vote on this item.
Supervisor Wolf.
Thank you, Madam Chair. I just wanted to talk a little bit about the money that has been allocated from constituents in CSA 3. I'm referring to page 6 of 12 on the budget revision request. This is really a good news story, and I wanted to highlight that the residents in the unincorporated 2nd District do pay CSA 3 funds for particular purposes, and I want to do a shout out to our Parks and Public Works for moving us forward on some really important plans. And I'm just going to read a couple of them. One is for its appropriations for the maintenance of the Kellogg tennis courts, plans for the San Marcos Foothill Park, additions to the Auburn Bike and Pedestrian Trail, and sidewalk improvements in the Thunderbird and Blueberry Hill open spaces, and that's for the current fiscal year. So again, my appreciation to the staff who has moved this forward, and I think that the residents that are paying for these fees will now, which they have in the last few years, seen some definite improvements. Thank you, Madam Chair.
Thank you. So, there are no more items pulled by supervisors, but we have 2 items that the public would like to address, A7 and A8. Would you read A7 into the record, Ms. Alexander?
Chair Hartman and members of the board, item A7 is from Behavioral Wellness. It is to consider recommendations regarding workforce education and training, Southern Counties Regional Partnership Service Contract with Loma Linda University School of Behavioral Health for fiscal year 2017 through 2019. And we are going to go to Santa Barbara for Sharon Byrne. Sharon?
Is Sharon Byrne in Santa Barbara? Can you hear us? We're ready to have you address item A7.
Thank you. I can hear you now. You went out for a couple of minutes there. I'm Sharon Byrne, and I am the chair of the Behavioral Wellness Commission for Santa Barbara County. I wanted to speak to you about an upcoming meeting that we're having tomorrow where we are going to propose and probably pass a site visit questionnaire where we would be able to go out as commissioners and visit with both our in-house service providers and our contracted service providers. The intention here is to assess how well we're doing in serving the people of Santa Barbara County for alcohol, drug, and mental health services. We'd be collecting client data as well and looking at how performance measures are being used and how well some of our providers are doing. So I just wanted to share that with you because I think it's pretty exciting work. A great subcommittee on the Behavioral Wellness Commission put this together, and they've done a good job creating it. We're going to run a pilot where we're going to visit the psychiatric health facility first and one of our contract service providers. We're hoping that we will be able to provide data to you that would give you good insight as to how well we're serving the residents of Santa Barbara County. Thank you.
Thank you for the good work. A8.
Chair Hartman and members of the board, item A8 is from the Clerk Recorder Assessor. It is to consider recommendations regarding the appointment of Santa Rita Hills Community Services District Directors. And we are coming back here to Santa Maria for Peter Kargasaki.
Good morning, Madam Chair, members of the board. My name is Peter Kargasaki. I just wanted to address you on this issue regarding an election for the Santa Rita Hills CSD. The board doesn't have jurisdiction to conduct this election. Basically, what's been presented to the board is 2 laws cobbled together that don't relate to each other. The first law was Government Code Section 61042C, to appoint vacancies on a board, which is basically a law that's created to appoint a board member to the remnant of an expired term, not to a new term. That has been combined apparently here with Election Code 10515, which is for general elections. So what's happened is that the appointment of a vacancy on an expired term is not a general election. You cannot combine these two laws to give yourselves jurisdiction to appoint a board. It contradicts itself. The second point I'd like to make is that when the board of the CSD expired, it was because the board had received a letter from our attorney, Patrick Morris, which informed the board and LAFCO that the board members, the directors, all have fixed habitation in other cities and do not reside in the CSD, so none of them were valid directors. So they allowed their directorship to lapse because they were afraid of legal consequences. So it wasn't, they were improper board members. And then the third point I'd like to make is that if there is to be directors appointed, it would require some kind of malfeasance because the Lakeview subdivision is a special problems area, and where are these people living that are claiming to have residency? Where is the sewage going? Where is the fire protection? Who exactly are we talking about here? So you would have to allow zoning violations to exist in order to appoint a new board. And the fourth point I'd like to make is that this actually is a violation of CEQA because the last 5 meetings of LAFCO, as Supervisor Wolf and Lavanino can attest, were related to matters all directed towards acquisition of condemnation and acquiring a 33-acre piece of land across my family's ranch. So it's not, what's the exact language, that it will not result in direct or indirect physical changes. This will indirectly result in physical changes because it's going to be going for condemnation for a 33-acre piece of land. And there's maps and there's also memos between the County of Santa Barbara and LAFCO related to this land in terms of an easement ownership claim, which in 1987, there's a minute order, there's multiple minute orders from the county saying that they don't have this interest. And now someone in the county is saying that it exists. So there's this whole finagling going on. And in that regard, because of the claim of ownership, the county has a conflict of interest as well.
And that is your time.
All right. Thank you for your time. I think I've made my points. Thank you.
Mr. Gazzoni, would you comment on this?
Chair Hartman and Supervisors, Office of County Counsel has been involved with the elections official for several years on this matter. The action that is recommended today for the board is an outreach action by clerk of the board. It's not a final decision by the Board of Supervisors, but the action is one that's proper under law.
Thank you. So, may I have a motion to approve the balance of the administrative agenda?
So moved.
Second.
And all in favor say aye.
Aye.
Any opposed? Agenda stands approved. Now is the time when we have public comment from members of the public on matters that are not on our agenda today, but you'd like to draw to our attention. Do we have any speaker slips?
Chair Hartman and members of the board, we have 3 requests to speak on general public comment today, and we are going to go to Santa Barbara for Linda Enty, to be followed by Brian Rosen. Linda? Is Linda still in Santa Barbara?
Dear Supervisors, the journey to this meeting forces me to be stricken with grief twice. Both the outward and inward trip dictate that I pass by the Gaviota rest stop facilities, where my son William, now 25, is forced into slavery by a conservatorship. He is bussed from a dismal semi-independent living home in Santa Maria daily to clean the facilities. William would love to live in Santa Barbara. However, the dictates of conservatorship will not allow such choices or enable him to realize his dreams of working with animals. My former spouse, William's conservator, Dr. Philip Enty, is misrepresenting his station at UCLA. He claims he is a professor of clinical neurology, when in fact he is not on staff and is part of a voluntary faculty. William was abducted and placed into a Tri-Counties Regional Center Level 4I home in 2010. This placement was in violation of our divorce agreement, where we had joint custody and I was the primary caregiver. Philip Enty was not William's conservator at the time. Details of this placement are written in William's IEP on February the 10th, 2010. Shortly thereafter, Dr. Enty was granted temporary conservatorship at a hearing whereby notice was served to my daughter and I 2 days after it had taken place. William did not have a hearing, and his request that I be the conservator was never addressed. I was stated the reason was because William is not capable of making good choices. William's capacity declaration was performed by a medical friend of my husband, Dr. Enty. Right now, I am not able to visit my son because Novellis is requesting, or actually saying for sure, I need to have another supervisor with me. This was not part of the judge's decision. If I had to pay for a supervisor to represent me, it would cost over $300. Judge Staffel says I need to be able to visit my son regularly, but this is not possible at all. Please help me with this terrible, tragic case. Thank you very much.
Our next speaker is Brian Rosen, to be followed by Siglin Reed.
Hello, I want to start today by sharing something. Your former colleague, Supervisor Carbajal, wrote this incredibly beautiful letter in support of human rights activist Isso Amro, who is for peace and nonviolence for the Israeli-Palestinian problem, and he wants equality and fair treatment for all, who's being held secretly and going to have a secret trial. And he wrote a letter on his behalf, and it's supported. And then he mentions I'm going to give you a copy of this, asking to drop all charges. Actually, he signed on to the letter that many other Congress people have. Highly respected human rights defender, I'm reading it, who advocates for justice, equality, and peace for citizens involved in the Israeli-Palestinian conflict. The letter has received support from the American Friends Service Committee, Jewish Voices for Peace, and the U.S. Campaign for Palestinian Rights, which are organizations that share principles of respect and nonviolence. These are organizations that also support the nonviolent boycott against companies that are profiting off of the illegal occupation and taking of land of Palestinians. And last week, Doss said that he was supporting that horrible bill that was so unconstitutional in order to protect Palestinians' jobs, which is really kind of far out because all the human rights organizations were against this bill. You name it. I've got a big long list here. The Quakers, the Unitarians have signed on to divesting from companies that profit off of this illegal occupation. The Methodists, I have some wonderful statements from all of them. The Methodists. And so it's chilling to our First Amendment rights to boycott them, and this kind of unconstitutional laws are passed, and representatives who violate the Constitution in this way really don't belong in government. Without economic freedom, we have no freedom at all. If we want to boycott, that's our right. That's an established precedent and our right under the Constitution. So to try to take that away, one pastor of a Methodist church says, BDS is a nonviolent response to the violence of Israel's military occupation of Palestinian lands and human rights violations. Many faith organizations, Presbyterian, Unitarian, United Church of Christ, and recently the Mennonites by 98% have chosen to divest and use that tool in support of Palestinian human rights. And they're losing their olive orchards, they're losing their homes, they're The United Nations says Gaza is unlivable with electricity reduced to 2 hours a day. So it's a serious concern. We need peace and equality for all people, and we don't need ridiculous attempts to violently subvert our Constitution. I'm really,
That is your
that's
time,
the main thing I
and
want
this
to...
is really not within the county's jurisdiction.
I understand that, but I just had to, it was such a flagrant violation of the Constitution. I had to respond.
Okay,
Thank you
thank
very,
you.
very much. Okay.
And our next
And
speaker is...
I'll
let
take the point of personal privilege on being named by name and just say that I of course, support that anyone's right to make their economic decisions. I actually encourage people to voice their views through not just the ballot box, but what they buy. However, I remain in the belief that the BDS movement, though well-intentioned, is not helpful in the cause of peace. I think that most people agree that good jobs in the West Bank would be good for Israel and good for the Palestinians, especially if they don't have to go through their checkpoints every single day to go to work. And the BDS movement includes in their boycott companies that operate in the West Bank. And I remain incredulous that it is foolish to include in any boycott companies operating in the West Bank, because you're thereby trying to encourage peace by putting Palestinians out of work. Repeat that, that it doesn't further the cause of peace to put Palestinians out of work in good paying jobs in the West Bank. That being said, I don't have any clue of how it's germane to anything that we're discussing today, so I hope we will remain focused.
Supervisor Adam.
Well, it's not, and I was just going to take the opportunity to have a point of order that we could just run the county here and stay within our pay grade. That would be just wonderful.
Okay, do we have any additional public speakers, Ms. Alexander?
We have one final request to speak, and that's Siglin Reed in Santa Barbara.
Okay. May I speak now? or-
Yes, please.
Yes. I would like to bring to your attention what my husband had to go through, my late husband and his mother. And when they tried to set up a contract, a trust, they came in contact with an attorney, and that attorney is working, probably still working, with senior planning. So senior planning, what they did was, it went all very fast. They put my mother-in-law under conservatorship. They threatened my husband to charge him with senior abuse and take him to court. And then when they had my mother-in-law under conservatorship, they took her to old age facility, so out of her house. The house was sold. The stuff of my husband was still in the house, everything he had, all his belongings. They very quickly changed the lock and then really threw everything, absolutely everything he possessed in a dumpster, and it was taken away. So he through that trust, he didn't get anything, any money, until his mother had passed away. In the meantime, his income, he was a high school teacher and had to leave because of a serious accident he had. He had to live and get his food out of trash cans. Only when his mother had passed away, he was able to lead a sort of more normal life. And I heard that senior planning is still operating in this way. I want to bring this to your attention. Thank you.
Was that our final public speaker? I just want to thank everyone who does speak in public comment and who brings items to our attention that we otherwise might know about. This issue of conservatorship has come up several times. And CEO Miyasato, would you say where we're going on this?
Sure. Chair Hartman, is Terry Nisich in the Santa Barbara hearing room? I know that she was going to be contacting folks there, but I know we have a group that she's met with and led. She's also referred the issues to the courts, and I believe the courts have said that the best place for our, some of our residents to go for the appropriate form is to first work through their own attorneys. But she is there to get any other information. I know she was talking to one of the people from last week that if we could forward any more information to the courts, we will.
And Ms. Miyasato, is this something that a report would be coming back to the board so that we better understand and can respond to constituents who raise these issues with us?
Chair Hartman, we'll be summarizing the information we heard and some of the issues we heard and what we can do or what we think the courts can do, and we will be providing that to you.
Thank you. Okay, that closes the public comment portion of our hearing today, and we're turning to our departmental agenda. I want to mention one more time that item number 4 on cannabis will be after our closed session, after lunch. So turning to item number 1, would you read that into the record, Ms. Alexander?
Chair Hartman, excuse me, Chair Hartman and members of the board, departmental item number 1 is from the Treasurer Tax Collector. It is a hearing to consider recommendations regarding the California Municipal Finance Authority financing of tax-exempt private activity bonds on behalf of Options Family of Services, Inc.
Ms. Christensen.
Good morning, Madam Chair, members of the board. I'm Jennifer Christensen. I'm your Chief Investment Officer with the Treasurer Tax Collector's Office, and I'm here to present item D1, which is a TEFRA hearing for Options Family of Services. TEFRA stands for the Tax Equity and Fiscal Responsibility Act of 1982. Rolls right off the tongue. Under Section 147F of the Internal Revenue Code, there is a process by which qualified 501c3s, like Options, can access the municipal markets. Thus, we have a request from Options to hold a TEFRA hearing in an amount not to exceed $2.5 million. The purpose is to refinance prior debt. I want to make it clear that the county has no legal or financial obligations associated with this issuance. The obligation is to hold a TEFRA hearing because the project is within the jurisdiction of the county. And I want to introduce the team. I have Debbie Bertrando from Options, as well as Roy Nelson, who has been serving as the financial advisor on this issuance, and then Anthony Stubbs from CMFA, which is the California Municipal Finance Authority. And with that, I would invite any questions. We would be happy to answer them for you.
Supervisor Wolf.
Thank you, Madam Chair. Thank you all for being here, and I'm supportive of this item. One thing that I look for in these hearings is just to confirm that the Debt Advisory Committee has reviewed it, and I think that they have, and they approved it, correct?
Yes, they have. We held a meeting on August 31st, and it was approved at that time, or recommended.
Recommended to the board for approval.
That the TEFRA hearing be held, yes.
Like I said, I'm in support of this. I think and it doesn't really matter what I think about what you're doing, but I just do have to say that I think you're doing excellent work for the community. And so I'm happy that this is before us and we can get this moving for all of you.
Any other board questions? Supervisor Williams?
I'll move A, B, and C. Staff recommendation.
And could we go out for, are there any public comment
Chair Hartman and members of the board, there are no requests to speak on this particular item.
Okay, we'd like your motion, Supervisor Williams.
Move the closure of the public hearing, which would be part of A, B, and C.
Second.
Okay, and was there any more comment people would like to make? Any on this item? All in favor say aye.
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 Any opposed? Motion passes.
Thank you very much.
Thank you. And next is item number 2. Ms. Alexander, would you read that into the record?
Chair Hartman and members of the board, departmental item number 2 is from Planning and Development. It is a hearing to consider the Planning Commission recommendations to approve the Los Alamos Cemetery project, which will effectuate a proposed land exchange of 0.9 acres between the Los Alamos Cemetery and the adjacent Carrari Family Trust parcel in the 3rd District.
Mr. Camp?
Good morning, Madam Chair, members of the board. My name is John Zorovich, Supervising Planner in the Development Review Division, and I'll be giving staff's presentation today. So the Los Alamos Cemetery District was established in 1888. The county cemetery, with the Cemetery District Advisory Board, is appointed by the Board of Supervisors. Peter Koparek, who is here today for the Cemetery Board, is the project agent. Next slide. So this slide shows kind of the general area. The project involves 2 parcels, which are roughly about 0.9 acres in size. The blue one, the one that is a light blue dot, that represents the area that is currently owned by the Cemetery District, and the green area is showing the general area that is owned currently by the Carrari property. And those 2 areas are the areas which will be involved in the lot line adjustment. Cemetery property is located wholly within the yellow shaded area of the Los Alamos Community Plan. This one here, represents the Los Alamos Community Plan in yellow. The Carrari property that has been in the exchange is located entirely outside of the Los Alamos Community Plan boundary. The cemetery property is zoned professional institutional zoning and has a cemetery comprehensive plan land use designation. The Carrari property is located within the San Antonio Creek Rural Region area with a land use designation of agricultural commercial and an Ag 2 zoning with a 100-acre minimum parcel size. Next slide. So the applications involved for the project, of these exchange and lot size is a pretty simple thing. It's just a swap of approximately 0.9 acres of land. But to get there, because of these different zone land use designations and where they're located, is a little bit more involved. One requires a general plan amendment because the area that is located within the Carrari property that's going to be given to the exchange with to the Carrari property from the cemetery to the Carrari property will be changed from professional institutional to agriculture. And the agricultural currently zoned property that's owned by the Carrari that'll be given over to the cemetery district will then have a change of land use designation to professional institutional. And so with the change of those land use designations are also the corresponding rezone to the similar land use designations for which the land swap will be done. And again, the lot line adjustment, and then we also have a government code 65402 determination involved with this as well. Next slide. So this slide shows a little bit of a close-up. So again, really what we're doing is swapping 0.9 acres of land. This is the area of land that is currently within the cemetery boundary, 0.9 acres, and is currently within the professional institutional zone district and within the community plan boundary of Los Alamos. This area is the Carrari property, and that's located on the ag property immediately adjacent and west of the cemetery district.
Mr. Zorovich, may I interrupt just for a moment? Is one of the properties is very steep, if I remember. I've done a site visit, and it's really, that's the reason underlying all of this is to get flat land for steep land. Is that understanding correct?
Madam Chair, that is correct. This area, so the cemetery district, this area, as you can kind of see here, is of a different gradient. It's not real steep as far as 30% slopes, but it does have a steeper terrain, which is not conducive to the cemetery use. And the land, obviously, that's currently being used for agriculture is much flatter. And so both are willing to do in the land swap. In the process of doing the land lot line adjustment. The applications were submitted to the APAC, Agricultural Advisory Committee, and they found that this is consistent with the ag rules, because the current Karari property is under an agricultural contract. So this kind of shows, I think the main point of this figure is really just showing how the new boundaries are. Here's the existing situation. This is the area right here which will be involved in the exchange. And then over here, you can kind of see a hatched mark. That's the area that'll also be involved for the ag property. So after the lot line adjustment, the ag property will then go all the way up here, consuming the kind of the steeper terrain. And then the cemetery district new lot, the northern lot, will have a configuration here that takes on the new area of ag land. Next slide. So as I mentioned, part of this is a changing to the land use or the community plan boundary. Here, right here in the blue is the cemetery district. Because this area of land will no longer be included in the cemetery, it'll be then outside of the community plan boundary. And then the area here that will be now part of the cemetery district will also be involved and is included in the adjustment to the community plan boundary. So when the lot line adjustments go forward, we also are doing an adjustment to the community plan boundary that effectuates this swap. And again, here's a map that's kind of showing the community plan and the zoning. This was professional institutional. So this northern parcel, this northern half, part of it will now be under the agriculture zoning. And this area here, not shown on this map, but this new configuration will then fall under the professional institutional zone. And then, as I mentioned, again, more of the process and procedures. The area of the Karari property is currently within the San Antonio Creek Rural Region area. So again, adjusting the boundaries will also result in an adjustment of the San Antonio Creek Rural Region area map to effectuate the change in the lot line adjustment. So today's staff is recommending that you make the findings for the project, determine the project is exempt from CEQA, adopt the general plan resolution, the zoning map amendments, approve the lot line adjustment, and receive the Planning Commission's government code. That concludes staff's presentation today.
Thank you. And Mr. Gazzoni suggests that we need to have ex parte disclosures regarding this item. So I'd like to say I did visit this site and spoke on several occasions with the board of the cemetery district in Los Alamos. Does anyone else have? Supervisor Wolf?
I have nothing to report.
Nothing else. Okay. So that
I have no ex parte communications on this.
Okay.
No, none.
All right. So are there any questions of staff about this item? Okay. Supervisor Williams?
Since you're the chair, but it's your district, I'll move the item.
Okay. And once again, we need to go out for public comment.
Chair Hartman and members of the board, we have no request to speak on this item.
Okay, we then have a motion. May I have a second? And a little discussion. I just want to say that this is a beautiful cemetery, and if you haven't been there and you'd love a beautiful hillside contemplative spot with big trees, it's a wonderful place to think about life. The second thing I'd like to say is that they have a first-rate board, and they've been working extremely hard because they're running out of space. They own the steeper part of the parcel, and so I think they came up with a great idea about how to get more space and more revenue for the cemetery. And finally, I'd like to thank staff, because it seems like a simple idea, but it took so many changes, and so it really took that handhold to get it through all of our county processes, and I'm very grateful for doing this. So we have a motion and a second, and all in favor say aye.
Aye.
Any opposed? Motion passes. So turning to item number 3, would you read that into the record?
Chair Hartman and members of the board, departmental item number 3 is from the Auditor Controller. It is a hearing to consider recommendations regarding the County of Santa Barbara's comprehensive annual financial report and financial highlights for the fiscal year ended June 30th, 2017.
Thank you. Mr. Filati.
Chair Hartman, members of the board, Theo Pilati, Auditor Controller, with me Flannery, our division chief for our financial reporting division. That's the division responsible for the preparation of these two publications. We'll start out with the county's CAFR. That's the acronym for County Comprehensive Annual Financial Report. And there's a picture there of the Gaviota Coast. The Gaviota Coast that has just recently been designated a scenic highway. What we'll go through today is a little bit of background about the CAFR, the reporting model, some contents, net position, some CAFR highlights. We'll talk a little bit about Government Accounting Standards Board pronouncements that are coming up, the financial highlights publication, our certificates of achievement, and then the action items for their board at the end. The comprehensive annual financial report, the most important part of it is the financial statements of the county, and these are audited annually, and they're audited. The audit is required by the government code. We do have a contract with an independent CPA firm, in this case Brown Armstrong Accountancy Corporation out of Kern County, Bakersfield. We're going to present the CAFR or the financial statements as dual purpose. One is the entity-wide, which is the long-term focus of the presentation of the financial statements, and then also included is the fund financial statements of a near-term focus. And so if you remember when we presented last month the annual the financial status report after the June 30 close, we talked mainly about the near-term focus and the actual individual funds and their performance, and today we'll concentrate on the entity-wide statements and their long-term focus. We did receive an unmodified or clean opinion from the outside auditors, and what that means is that the financial statements present fairly the county's financial position and the results of its operations for the year ended June 30, 2017. It was prepared, audited, and issued within 60 days of year end and provides timely and accurate reporting. The CAFR reporting model is made up of the management discussion and analysis, and these are changes where we discuss the changes in the net position and results of operations. Additionally, the financial statements themselves in both the fund level, which is the budgetary basis by fund, that's the box on the right, and then also the government-wide, which is a combination of all the assets and liabilities of the county. Integral to the financial statements are the notes to the financial statements, and those are explanations of the items that are included in the financial statements. Additionally, we have the required supplementary information, which is required for our pension and OPEB disclosures. On this slide, we're basically go through a highlights of the table of contents. These are some of the important pages within the CAFR itself, and with a reference number for you to take a look at. What we have here is a high-level roll-up of basically the countywide assets, and the actual detail of these assets and a listing is on page 30 of the CAFR, and you can see if you wanted to see individual items that make up the main categories there. What we'll focus on here is that our assets increased by $74 million during the fiscal year, and that we also had an increase in deferred outflows and outflows of resources, and the main components here of the current or the assets is an increase in investments of $29 million, cash and investments that make up part of the $42 million, and then also accounts receivable increased by $11 million. In the deferred outflows, we had $114 million of an increase, and that is typically from deferred pensions, and these are the timing differences between the measurement date, which is June 30 of 2016 for the pension plan, and the June 30, 17 presentation of our financial statements. And some of the differences there are the differences between the projected and actual earnings, and then also the payments that were made during the 16-17 year that are related to the, that are subsequent to the measurement date of the pension plan at June 30, 16. Next, we'll have the high level also roll up of the liabilities, the countywide liabilities, and the same detail of those items are also on page 30. We had an increase in total liabilities of $116 million. And that was mostly, the current liabilities of the 17 was made up mostly of advances from grantors and third parties. In this case, these are mitigation fees that are collected and are not available to be spent until the projects are ready. And so that's 11 million of that total. We also had an increase in accounts payable of $5 million. In our long-term liabilities, we had our COP bonds and notes payable decreased by $5 million. However, our net pension liability increased by $104 million. And then in our deferred outflows, you can see small amounts. We have deferred SCAs, and those are service concession agreements. As an example, it would be revenue coming in from the county bowl or from the restaurants that we have at our county beaches that are going to come in the future. And then deferred housing loan payments, we increased the principal amount of outstanding loans on the collectible non-forgivable loans for the housing program. And then deferred pensions, again, a little bit of timing difference between the 2 years of the measurement focus and the end of the year. Next is countywide net position, and here you can see that our change in the net position is $55 million. So we had a total net increase after the results of operations, where and then the individual categories that make up that, we had net investments in capital assets went up by 38 million. Majority of that is due to addition of work in progress, infrastructure, and the Northern Branch Jail. In restricted net position, we had an $18 million increase, and that's mainly in the restricted funds such as fire and also the 109 in the probation department, AB 109 revenue, and then a couple of other smaller amounts in other funds to make up the restricted increase. And then in the unrestricted net position, we actually had a decrease of 1.8 million, and that is generally, it's the net of an increase in the government pension and our post-employment liabilities of 10.3 million, and offset by increases in committed and unassigned government fund balance in our business, proprietary type activities, and our ISFs. So the bottom line, though, we did go up in our net financial position for the year. Again, rolled up overall, the countywide revenues. We had an increase of $30 million in our program revenues. We had an increase of about $12 million in our general revenues. And there's a description there of the program revenues, the components, the main components that make up the increase. And then also on this next slide, we have our countywide expenditures, and they went up by 47 or almost $48 million. And you can see there in which categories or which functional areas those increases took place. The main increase is $35.9 million in salaries and benefits, and then of which $30 million, 30.8 was due to an increase in the retirement pension expense. And what we had in total was, for the year, we had an increase of $55 million in our net financial position in comparison to the prior year, where we had a $60 million increase in our financial position. So between the 2 years of comparison, we had revenues in this year. The difference was a decrease of $5 million, but there were increases in both years. That's just a comparison figure. And that kind of information is all on page 19 of your CAFR. Typically, we'd like to point out or highlight one or two major components of the assets and liabilities each year. And in this case, we have the cash and investments. And What is presented here is actually the total treasurer's pool. And what you can see there is all the pooled investments, what types of investments they are, what their cost and the value is, and then also their interest rates and their typically their due dates and their weighted average maturity. Now, this represents all of the money in the treasurer's pool, and the county's portion of that is $420 million, or about 30% of that total. So again, this is and with the remainder of that being mostly the school's money, and then also other special districts that have their money in the treasury. And then, so that 420, which is the county share, compares to the prior year we had 390,000. So we had a $30 million increase in our cash and investments for the county itself. In the long-term liabilities, you can see here that actually our long-term liabilities net increased by $99 million, and really it was primarily driven by the $104 million increase in the net pension liability and a $2.5 million in the OPEB obligation. There was a slight increase of almost $2 million in the landfill post-closure and care costs also. But you can see that for the most part, our other liabilities are decreasing as we're paying off debt, and then unfortunately they got offset by an increase in the pension liability. Next slide has the pension liability, and there's a comparison there of the county's share. You can see what percentage the county is of the total pension plan, and also what the county's net pension liability is, and there's 4 years are presented there. To see, and then the bottom line is the percentage of funded that the plan is funded and the county is funded in that plan. Talk next about some upcoming GASBs. GASB Statement 75. GASB is the Governmental Accounting Standards Boards, and they provide all the promulgations and the guidance for the standards of accounting for the county and governmental entities. We're going to in this next year, we will add the full amount of the liability of our other OPEB or other post-employment benefit plans that we have, and that's mostly our retiree medical. Also then a new change will be leases. Basically they're going to make all of the leases that we have capital leases so that they'll appear on the balance sheet. Even the rents of buildings, rental contracts for buildings will end up being intangible assets on the balance sheet, and then also the liability itself will end up on the balance sheet. And those are the main significant ones that are going to hit the county. Next we have our financial highlights. It's an annual presentation that we do to sort of summarize the county's finances in a reader-friendly manner. We've got a couple of new sections this year for 16-17. We've added the top 10 employers and also the top 10 taxpayers. We've added the sources and uses of the county general fund, and then information on the Northern Branch Jail, and also the county pension liability and projected contributions for the pension plan itself. Our theme the prior year was steady improvement, and this year basically our theme is temperate growth. So as I described last month when we presented the financial status report. Both these publications have been submitted to the GFOA, Government Finance Officers Association, and both these publications have won these certificates of achievements, the CAFR since 1991 and the Financial Highlights since 1995. And we ask for questions at this point, and then we would ask for you, the action item, to accept and file these reports.
Are there any questions from the Board of Supervisors? Supervisor Adam.
Well, I don't know that it's really a question, but it seems on page 89 that we have an awful lot of separate line items here, 89 and 90. There's one that are clerk, recorder, assessor, fund balances, and they all kind of maybe there's a separate explanation for each one, but they all sort of look similar, and there's a boatload of money in there. Recorder modernization, 1.8 million. Recorder operations, 1.3 million. Assessor AB 818, which I don't know what that is, 504,000. Recorder micrographics, 360,000 odd. Recorder redaction, 250,000. Recorder ERDS, 134,000. And clerk recorder assessor projects, 1.7 thousand. You know, so the large ones are the 1.7 million rather, and that's modernization, operations, and projects. So that's kind of sounding similar to each other.
Not having the detail on each one of these, however, the ones that are listed on page 89 are restricted, and typically that's going to potentially it is money that could be restricted for elections purposes, legally restricted for elections. Recorded micrographics, I believe that they receive a portion of a fee on documents that are recorded, and that they're required to spend that on either modernization or computerizing their records and those kinds of things. So I would say that the ones that are listed here on 19 have restrictions from the outside, either potentially government codes. I know AB 818 was a loan program where the state loaned money to assessors to help get rid of their backlog of assessed properties, and so that's got to be used specifically for that. The ones that you could potentially focus on would be if there are any on page 90, which are the committed fund balance, and those committed fund balances there on page 90 are the ones that your board has complete discretion over.
Right, okay, so there is the one there at 1.8 million, and so that's, when it says committed, that just means that it's there for the clerk, recorder, assessor to spend, right?
That's correct. It was committed by an action of the Board of Supervisors with either a budget revision or the adoption of the budget.
Right, but it doesn't, it's, the term committed means what?
It was committed for a specific purpose brought forward by the clerk recorder.
And it has to be spent on that purpose?
Your board has basically complete discretion over anything committed.
Right, but so the idea that it is actually committed to that thing is a little bit of an overstatement of the term committed. I'm just trying to inform the public a little bit here.
Sure.
That the term committed fund balance doesn't actually mean that it's committed to whatever it says it is.
The department brings forward a request with a budget revision or as part of the budget for your board to commit those funds to a specific project or purpose. And when the board adopts those budget revisions, then they are agreeing to that commitment. But it does not mean that the board cannot have the discretion to change that commitment should they so choose.
Right, and when you're dealing with a elected official like a clerk, assessor, recorder, there's even a different level of discretion in terms of spending that money, right? Or the auditor. I mean, I'm not trying to pick him out.
So you have the same control over the committed ones, irrespective of what department and a department head, whether it's elected or not.
Okay, so if we, for instance, if we gave you $1.8 million as an elected official and you didn't spend it, what would happen to that next budget year?
If it was totally not spent, then it would roll over and remain in that committed fund balance until there was an action to release it.
Okay. Okay, good deal. Thank you.
Any other questions for Mr. Filati? Are there any public speaker slips?
Chair Hartman and members of the board, we have no requests to speak on this item.
Okay, I just wanted to say that I really appreciate the quality, and I use this as cliff notes regularly when I have to explain things about the county finances. So I really appreciate how clear you've made it for us.
Thank you. Yes, I think we all use it as talking points when we're speaking with public groups.
All right, may I have a motion?
I'll move staff recommendations.
And a second? All in favor say aye. Aye. Any opposed? Passes. I'd like to take a 10-minute break. We'll be back then to start on item number 5 and 6. We're delaying 4 until after lunch. And we're turning to item number 5 in our agenda. And Ms. Alexander, would you read that into the record?
Chair Hartman and members of the board, departmental item number 5 is from Public Health. It is a hearing to consider recommendations regarding a proposed amendment to Chapter 7, Animals and Fowl of the Santa Barbara County Code.
Thank you. And Dr. Del Reynoso, this is your first presentation for the board, and welcome. We're delighted to have you, and Ms. Glick as well.
Good morning, Chair Hartman and members of the board. Today, the Public Health Department Animal Services Program brings 2 items forward for your consideration. The first department item is a proposed amendment to Chapter 7, Article 3, the license and tax section related to anti-rabies vaccination. Notification to animal services from veterinarians when dogs are vaccinated against rabies will support timely licensing of animals, reunification of lost dogs and owners, increase revenues to the program, and protection to the public. Now I'd like to introduce you to Jan Glick, Director of Animal Services, who will provide a presentation on the proposed ordinance change.
Good morning, Madam Chair and members of the board. In regard to background on the request for the licenses and tags section of Chapter 7, all of the counties in California are declared rabies areas. This means that rabies can exist in any county within the state. And the state mandated dog licensing is clearly related to prevention of rabies for both pet animals as well as the human population. Only licensed veterinarians can administer rabies vaccinations, and local ordinances may require veterinarians to report rabies vaccination records to ensure compliance with licensed laws. This is considered a best practice in animal welfare organizations and animal services, providing services to both cities and counties. And we did, as part of our project, send a letter to all the veterinarians practicing with small animals in Santa Barbara County to advise them of this recommendation. We have a number of benefits of animal licensing, particularly dog licensing. They protect the public health and safety. They provide identification, which assists in reuniting pets. All of our officers have the onboard computers, as you know. So if the dog is wearing a tag, they can return it without even bringing it to the shelter by doing a search from their vehicle. It reduces the number of surplus and homeless pets by encouraging spay and neuter through education and the differential license fees. And the differential is a state requirement. And it provides necessary revenues to continue funding the field and shelter operations relating to stray and homeless pets. Our recommendations are that we amend Chapter 7 to provide for vaccination certificate requirements, and that we include a requirement for veterinarians to provide the copies of the rabies vaccination certificates to the Animal Services Division. So recommend actions for the board this morning are approve the introduction of the ordinance amending Chapter 7, Article 3, license and tags required. That would be this morning. Waive full reading of the ordinance, continue the ordinance for second reading to October 3rd, and determine the actions are not a project under CEQA. We're happy to take any questions.
Supervisor Lavanino.
I had one. Thank you, Madam Chair. And I don't know if it's under 5 or 6. I read it somewhere that I had a question about the, I don't know what it's called, like an abandonment fee or somebody that drops off an animal at a shelter. Is that in this item or the
surrender
next
free.
item, or
I don't
Or are
see
we
it
even
in
talking
either.
about-
It was
Oh, okay.
flagged in a
It was in an
communique
email,
to
yeah.
us, but I don't think we're considering that today, are we? The surrender fee when somebody drops
surrender
off
fee
their pet.
increase? It's not in this.
Supervisor Lavanino, through the chair, surrender fee is not being considered as part of this or the following item.
Okay.
Fees in total are planned to be brought to you in the future.
Okay. Well, when that comes, if you could just, for me, I'm surprised anybody pays that at all. It seems like an incentive to just leave an animal somewhere else in a neighborhood or something. So we'll need to talk about that when we get there.
But at least the issue is flagged for future discussion. Are there any other questions? I had a couple. Have we reached out? One, I very much support this. But two, have we reached out to vets so that they know this is coming? And could you talk a little bit about how we can make it as easy as possible for them? I mean, can they email something, or do they have to have staff and put things in an envelope and all of that? And then when it comes to us, could you talk about the process that we have for how we reach out to people? The mechanics.
Chair Hartman, a member of the board, we did send a letter to all the local veterinarians advising them of this upcoming change and requested change, and advising them of the methods that would be available for receiving the certificates from the veterinarians. We work closely with the veterinarians in the community, and many of them already sell dog licenses as part of a voluntary program that we've had for a number of years. So this will possibly expand on that, and it will allow them to provide those certificates to our staff when they are at their clinics, picking up any licenses that may have been sold. We also will be offering an electronic version. If they would like to submit those to us electronically, we can send staff members to clinics that don't participate in the voluntary program to pick up the certificates, or they can be remitted by mail. So we want to be really flexible and customer friendly on that with the vet community. We really appreciate the collaboration that we have with the community, and we want to continue to build on that.
So vets can issue dog licenses. My vet doesn't, so I'm glad to know. What proportion of vets in the county do that in unincorporated county?
It's pretty close to half of our veterinarians throughout the county, and even those that are in incorporated cities, because their clients can come from any part of the county, and we do provide the services for 6 of the 8 cities full services, so we provide the licensing program for those cities. So it's been a very beneficial program for us. The veterinarians have been very helpful in the compliance aspect, and we look forward to more collaboration in that way.
And it's one-stop shopping. I have 4 dogs, and so that makes it much easier. So I'm going to my vet and ask them to do it. Supervisor Williams.
That was going to be my suggestion. That's why I took my light off. I was like, I think you need to lean on your vet to start participating in the licensing.
Okay, I see no more lights up here. Do we have any public comments on this item?
Chair Hartman and members of the board, we have no requests to speak on this item.
Okay, bring it back to the board, and we see what the motion is up here. Supervisor Wolf?
Thank you, Madam Chair. I'll move staff's recommendation.
A second?
I'll second.
Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes. So turning to item number 6, would you read that into the record, Ms. Alexander?
Chair Hartman and members of the board, departmental item number 6 is from Public Health. It is a hearing to consider recommendations regarding a revised ordinance to amend Chapter 7 Animals and Fowl Vicious and Restricted Dogs of the Santa Barbara County Code and recommended revisions to the Animal Services Fee Ordinance.
Chair Hartman and members of the board, this is another ordinance proposal, and it is related to vicious and restricted dogs. This change is brought forward after 2 years' experience following extensive revisions in this section. The ability to address egregious first-time dog attacks and impose fees for hearings will improve protection of the public and streamline our process. Jan Glick, again, will provide the presentation on the proposed ordinance change.
Madam Chair and members of the board, in the spirit of continuous improvement, we're back here with additional recommendations for revision of the vicious and restricted dog section of Chapter 7 of the county ordinance. As you know, ordinance changes were made November 3rd of 2015. And those changes, as we've operationalized this and gone through numerous hearings throughout the county, we have found they do not fully address egregious first-time incidents with domestic animals and livestock. So it really only addressed attacks on humans for a finding a vicious dog, and we feel that we want to bring this back and recommend that a finding of vicious dog in some instances may be appropriate with an egregious action towards an animal. Fees related to the enforcement of the ordinance will help offset the costs of the hearings and the investigations related to these cases. So our recommendations are that we add a definition of severe injury to an animal, that we amend the definition of vicious dog to include a dog that has made a first-time attack on another animal, and that we add clarifying vicious dog definition, add language clarifying the vicious dog definition, taking into account prior documented behavior. We also want to require owner to notify if the county if moving or rehoming a restricted dog. We would like to authorize a hearing officer to order seizure if the conditions have not been met, and impose new fees for costs in cases where a dog is adjudicated to be a restricted dog. A fee study was conducted to establish our estimated conservative costs for investigations and hearings, and that is based on staff time with the conservative estimate being our base as to how we establish those fees. The fees have been reviewed by the auditor's office, and we did find that San Luis County has very comparable fees to what we're proposing. So our recommendations include that you approve the introduction of an ordinance today, that you waive the full reading of the ordinance, that we continue the ordinance for second reading on October 3rd, approve the introduction of an ordinance amending the fees, waive the full reading, and continue for second reading. This looks like I have a typo on the slide, I apologize. And determine the above actions are not a project under CEQA. I would like to advise the board that we received some communication within the last few days regarding a request that one additional amendment to the ordinance be considered, and that is under the definition of the vicious. This is something that had come up years back when we came forward, and we didn't address it then, and subsequent to this, the state has actually changed the state code in the vicious definition. So if it's acceptable to the board, I'd like to bring that up on a slide and show it to you for your consideration. Can we make it any bigger? So this is, if you have a copy of the ordinance, it's under section 7-54. Number 2 is the definition of vicious dog, and the part that's highlighted here in yellow is recommended to be considered to be stricken out of the definition of vicious dog. And it reads,
Can you read that for the record, please?
any dog that engages in or has been found to be trained to engage in exhibitions of illegal fighting. So that would be deleted from a mandate that that dog would automatically be considered a vicious dog, and every dog would be evaluated as to its behavior on an individual basis. That's the end of our presentation. We're happy to take any questions.
Supervisor Wolf, your light was on, but maybe from the motion. Supervisor Lavanino?
Thank you, Madam Chair. So in, under the vicious dog definition, after 9, on ours it has a strike through saying the provisions of this section shall not apply to any dog assisting a peace officer engaged in law enforcement. And that was stricken. Why was that stricken?
It was moved to another section, Supervisor Lavanino.
So that's still, they still have that
Yes, they do.
coverage? Okay,
Yes, they
thank
do.
you.
Supervisor Williams?
Just want to support the ordinance and just say that the logic of striking A, in my view, is pretty sound. We made the determination to strike this out of state law because there are some pretty well-known cases of sound rehabilitation of former fighting dogs, and just better to evaluate them on an individual basis than to assume that all former fighting dogs, even those that have gone through rehabilitation, should be designated as vicious dogs.
Okay, and I just want to make sure I understand. So we have a distinction between restricted dogs and vicious dogs, and if I understand it correctly, one of the characteristics of vicious dogs, that is restricted dogs, I'm sorry, that is seriously attacking domestic animals or livestock, that now will go under vicious dogs. Is that basically what we're doing here?
Supervisor Hartman, that's correct. For the egregious cases where the attack is severe, we want to be able to address that as a vicious dog.
And then if a dog comes into the county, say, and it has a previous record, we can now count that record. So it could be a vicious dog before having an incident in our county. Is that correct?
Chair Hartman, that's correct. The other aspect we want to be able to include is previous documented behavior that we have in our records, which we didn't realize when we crafted this in the past was not going to apply unless we specified it. So we've added that as well.
Good. And I just wanted to echo what Supervisor Williams said. In fact, this might be known as the Lee Heller Amendment. She tracks these issues and sent emails out, I think, to everyone, but she noted the dog, the film about the Michael Vick's fighting dogs, and most of those were rehabbed. So it's usually the owner and not the dogs, but sometimes the dogs suffer the consequences for poor training and poor control by owners. Okay, now is time for public comment. I understand we may have some images that are graphic, and people who are sensitive may want to be alert to that. So, Ms. Alexander, how many comments do we have?
Chair Hartman and members of the board, we have one request to speak on this item, and it is in Santa Barbara for Suzanne Duca.
Supervisors, it's my pleasure actually to be here today. I have asked for just a couple of images that you may have received in a letter I sent to you in anticipation of your July 11th meeting on this matter that was postponed until today. I have a copy of the letter. It may be in your package, which gives you a more detailed description of what my cohort, Sarah Moore, and I suffered. There I am on my horse on a normal day at the beach. That horse is now in retirement after having been terrorized, bitten, and chased down the beach for a half a mile. It is, I guess, has post-traumatic stress syndrome. You can't trust it around dogs anymore. The other horse, and this will be the next photograph, this is the veterinarian's hand inside the other horse's chest after a dog that was determined to be restricted and not vicious created that evening as the vet sewed the horse up. Sarah put herself between me and between me and the dog in order to protect me. She's a stronger rider. I didn't put up the picture of the flank wound, but she easily could have lost her leg or had her leg severely damaged as the dog was jumping up all around the horse, biting at it. And you know, if you're a horseback rider, where your horse is, it's right in front of the flank where the bite took. Well, here's I don't know. Can you see these photographs? Here's the flank.
We're looking at the photograph with the blue glove and the finger showing the wound.
Okay. Well, yeah, I didn't want to show you everything. So it was horrifying. My horse bucked and was backing up as I got thrown off backwards. It's just amazing that it didn't stomp all over me as it was backing up as it was rearing. And I really was, modestly bruised. For about 3 weeks, I kind of limped around with a sore back. So now I I've experienced most everything that's being presented to you today for correction. I've been through a public hearing, seen a dog restricted, seen the person whose dog was restricted never having to even pay a single nickel of expenses for that. Seen that same dog later on participate in another dog attack at Elings Park in the dog leash area, in which it badly attacked. Here comes the third slide. It shows you the dog sewn up. It's not so bad. Did you want to put that third slide on? No? Okay. Well,
we are seeing the third slide.
Oh, okay, good. So this person, after her dog had been restricted, took it to a leash-free park where, of course, the dog attacked another animal, and that dog was ripped up. Again, she went through a public hearing in the city, and that went in its own direction, but the county then was not able to use the evidence that was obtained from the city to come back to the county for any kind of secondary hearing. So I have gone through all of these steps that you're trying to correct today, and that's why I'm here to support those corrections, because we dodged a bullet, let's just put it that way. And maybe by passing these things, other people will have a bit more safety. This is really truly an improvement for the common good. So thanks for hearing me out.
Thank you very much. And there are no more public comments. So I bring this matter back to the board, and Supervisor Wolf.
Thank you, Madam Chair. And I just want to I want to thank staff for bringing this forward to us. I think I read about this incident in the newspaper, and I was really pleased when we were going to hear it in July, and I suspect it's been refined to today's hearing. But for those who don't know the history of us redoing this ordinance, it took us a long time. And for those of us that were sitting up here, the definitions between vicious and all the different definitions for our animals it was a pretty heavy hearing for us to go through that. And obviously, the ordinance that we passed wasn't perfect. And I think today we're getting to that, hopefully, that point of perfection. I think this is a definite improvement to our ordinance, so I appreciate staff's work on this. I also want to, I also got that email that staff mentioned, and I'm glad that we now have an easy fix so that we don't have to come back and rehear this ordinance again. So I'm definitely in favor of what you've done. And I also, just as a side note, you know, we had so many complaints about animal services a few years ago, and it resulted in a report with many improvements to be initiated. And I think, or I believe, that we've seen such an improvement between staff relations. Of course, I think the funding has been enhanced to some degree. So I think we're moving in the right direction, and I really am hopeful that this ordinance will, if it's not perfect today, that it will be, well, I'm going to assume that it's perfect. It's my assumption. Thank you, Madam Chair.
Supervisor Williams and then Supervisor Adam.
Well, first, I want to speak to Ms. Duca and just appreciate the constructiveness in which she has endeavored to improve county policies since a traumatic episode of that type. To sort of give you even more of a feel for what happened, my understanding from eyewitnesses was that the dog owner that attacked then was incredulous at the equestrians for being there, which kind of gives you a sense of some people's entitlement mentality, that even after their dog attacks something, will blame it on someone else. But since that time, we've watched your case really closely, so has Animal Services, and she's been incredibly constructive. I even think that she helped us out with some equipment that will help enforcement down at the beach better. So I just think that that's, especially given all that happened, to wade into this deeply, but to do so in a rational manner and to pursue policies that are rational is really commendable. Secondly, I just want to thank staff for being open to ideas from the community. Even in the last few days, I know they were open before, which is part of why the delay happened, and but it will make a better ordinance and hopefully one that better deals with these cases and provides some more safety out there and for both pet owners and their pets.
Supervisor Adam.
Yeah, and as a guy who works with animals on a frequent basis of at least 3 species, the animals always pay. And for those of you out there that think that we're being mean potentially to an animal because, through no fault of its own, it's engaged in some behavior, it's always the people's fault. It's never the animal's fault, but the animals pay for the bad behavior of the people. And so, it just highlights the need for people to take responsibility for training their animals and to have control over their animals all the time and keep them out of those problems. There's just no excuse for that kind of behavior in an animal that would cause those pictures that we saw there. So I hope this gives us the tools to be able to solve that for the people who won't solve those problems by really just keeping their animals out of those kind of situations.
And I would just like to add that moving the dogs who hurt other animals from restricted to vicious it's people are going to protect their dogs. People riding, I'm just so grateful that the people riding horses were not terribly injured. That could have been a death or a serious injury forever. So I think this is also a call. I'd like to echo what Supervisor Adams said. You know, all of us need to take better control of our dogs when we're out in spaces, open spaces, beaches, dog parks, parks without leashes. We don't always know how they'll behave. So before we let them off the leash, in places only where you're allowed to leave them off the leash, be sure that they're reliable. So with that, I would like a motion.
I'll move staff recommendation with the change of striking subsection A from the vicious dogs as is articulated above.
I'll second.
Chair Herman?
Yes.
And as I understand the motion, that would be, as staff is showing on the screen right now, at section 7-54-2, deleting the words "any dog that engages in or has been found to have been trained to engage in exhibitions of illegal fighting," and then it requires relettering and of the sections just to match throughout.
That's the intent of the motion.
Okay, all in favor say aye.
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 Any opposed? Motion passes. It's early, but I think we're going to close session, and then we'll be back after that to hear item number 4. Mr. Gazzoni, would you tell us what's in store for us today?
Chair Hartman and Supervisors, I estimate about an hour and a half for closed session. We first have 2 existing litigation cases, County of Santa Barbara versus Zinke and County of Santa Barbara versus Pacific Regional Director, Bureau of Indian Affairs. Both of those cases involve Chumash Camp 4. We then have conference with legal counsel for 2 cases involving decision whether to initiate civil litigation. We have 1 conference with legal counsel for significant exposure to civil litigation. And then you have a conference with labor negotiators for all bargaining units, unrepresented employees, managers, and executives.
Thank you. So it's hard to predict exactly, but we imagine that we'll be here 12:30 to 1 o'clock to take up item number 4, cannabis.
Why don't we, let's just say, can we just say 1 o'clock so we have a time certain so folks don't have to come back and
Okay,
guess?
1 o'clock, that's
Yeah, I
fine.
think we already told them 1 or 1:30,
Okay,
so.
good, 1 o'clock. Good afternoon, and thank you for being here. It's the September 19th, 2017 meeting of the Santa Barbara County Board of Supervisors here in the Santa Maria hearing room, and we're turning to item number 4 in our agenda, but first we need Mr. Gazzoni, our county counsel, to report back after closed session.
Chair Hartman and Supervisors, today in closed session, the board considered 2 matters of existing litigation, both involving Chumash Camp 4, County of Santa Barbara versus Zinke, and County of Santa Barbara versus Pacific Regional Director, Bureau of Indian Affairs. You also had conference with legal counsel for 2 cases of anticipated litigation, conference with legal counsel for 1 case of significant exposure to litigation, and conference with labor negotiators concerning all bargaining units, unrepresented employees, managers, and executives. There are no reportable actions.
Thank you. Ms. Alexander, would you read item 4 into our agenda?
Chair Hartman and members of the board, departmental item number 4 is from the County Executive Office. It is a hearing to consider recommendations regarding a status report on the ad hoc subcommittee on cannabis operations and discussion of conceptual cannabis licensing and land use permitting options.
Thank you. And I'd like anyone who wants to speak today to please get your speaker slip in so we can figure out how to allocate the time. Mr. Bozanich or Dr. Russell, which is leading us off? Oh, Mr. Bozanich.
Thank you, Chair Hartman, members of the board. We're glad to be back with you. At your July hearing, you asked us to come back to present some additional information to you. So we are here at your request. Just to give you a status update on the regulation development being conducted in conjunction with the ad hoc subcommittee. Staff has met with the subcommittee 13 times since March. At this point, we have now conducted 3 town hall meetings and 2 EIR scoping meetings over these past several months. There are currently 5 working groups generally focused around land use and development code amendments, business licensing, tax measures, health impacts, and enforcement planning are the kind of major working groups that staff is working under. There's also underway an effort to bring back to your board, as you requested, a process for determining legal nonconforming uses within those under the medical cannabis, Article 10 in the county ordinances, to bring that back with some additional options, and then also an amortization period to bring those legal nonconforming properties to a close in a reasonable amount of time. Also, it's important to remember that we're in the midst of the preparation of a draft EIR that should be completed sometime shortly in the next couple of weeks. I know chapters are being reviewed at this time, and that will be brought back soon, as well as for public meetings, and we'll have that in the schedule at the end of our presentation this afternoon. And then also the economic analysis report should be completed sometime in October. And as you'll see in the draft schedule for how we proceed with your board in the future, the plan would be to bring the information from that economic analysis, which has a look at both the staffing costs as well as potential tax revenue options. That would be brought to a hearing of your board, full board, on November 7th. For your possible considerations. So the purpose of today's update, and really this is a direct result of the request of the board at the hearing in July, was to present a report on the conceptual licensing and zoning options for cannabis in Santa Barbara County. To receive some public comment on those conceptual licensing and zoning options, then to provide general direction to staff on those conceptual licensing and zoning and regulatory options, and then receive direction for staff to return to the board in November with another status report. It's important that note that as we talk about conceptual licensing options, whether it's about licensing, zoning, permitting, this is really in the context that your board is making no firm decisions today. Your board will have the opportunity to revisit decisions at multiple points in the next several months, and you may change your mind at any point, but at this point, the intent of this particular session today, as was requested, was for you to be able to provide input into the various kinds of licenses and zoning options that might be available for you to consider at a future date and to give staff direction as an entire board. So some of the regulation options ahead of you today is, first of all, always the option to prohibit some or all cannabis operations. That option still remains on the table going forward. Your board could choose today to conceptually direct us to prohibit certain cannabis operations and then change your mind later on and follow through with a different course, but you could today give us that direction conceptually. You could also consider conceptually allowing state licensing of cannabis operations with local land use permits as our only regulation of cannabis operations. So it would be just an option for state licensing only on the state licensing of the operations, the operators, the licensees, and then land use permits would be the controlling way in which you would be able to exercise some influence over what happens and where. Third option would be the board also has the discretion to establish local cannabis business licenses, more stringent regulations and requirements than the state, and also local land use permitting requirements to provide a regulatory structure for the cannabis industry. So again, just to recap, your board today could give us conceptual direction around prohibiting some or all cannabis operations, or your board could give us direction to proceed with zoning and permitting regulations on the local level and allow all the state responsibility for all the licensing of who is involved in the cannabis industry. Or your board could give us direction around establishing a licensing structure to determine who is involved in the cannabis business in the county, a local licensing. They could also have a local permitting and zoning requirements established by this board. And then they would also then be required to qualify for state licenses in order to operate in this county. If not prohibited, the most comprehensive regulatory system would be to require each cannabis business to be in compliance with state licensing, local business licensing, and local land use permitting. Aligning state and local regulations would also reduce confusion and enhance enforcement. One way to think about this is the infamous Venn diagram, or another way of thinking about this is a three-legged stool, and sorry, the colors don't display very well here on the projector. But one way to think about this is that state licensing and industry regulations are one leg of the stool, or one component of this licensing system. Another one would be local regulations via land use permits, which would determine where and how cannabis operations would occur in Santa Barbara County. And then lastly, that you could add a component of local regulations via business licensing that would determine who's involved as in the cannabis business and what specifically they are allowed to do, and by extension, what they are not allowed to do. And the perfect kind of sweet spot would be in the intersecting points where all of those come together. Those would be the people who would be operating in Santa Barbara County, or the people in the middle of that diagram. So it's a little bit of a idea. So if we were going to do business licensing, and again, I want to separate out business licensing from land use permitting for just a moment. One possibility is to use this structure and the types of licenses that the state already has. And I think we've mentioned before, there are 17 licenses authorized now under state law following the trailer bill, SB 94, that the governor signed back at the end of June. And you could follow the structure. And just to kind of walk you through the cultivation licenses that you see on this particular slide, you'll notice...
Madam Chair, just a second. Oh, I'm sorry. Dennis, did we skip a slide?
Did I?
Is there 6?
Oh,
yeah.
Shoot. Oh, thank you. Thank you very much, Supervisor. Sorry, I will go back. This is a little bit of a recap, but probably helpful before I jump into the other slide. So land use permits could be used locally to regulate where cannabis operations occur, and by extension, where they can't occur, and how cannabis operations are to be conducted. It's important to note that permits of this type are attached to the property, not to the person. Business licenses could be used to determine who's allowed to conduct the operations and what specific cannabis operations they are allowed to conduct. And important to keep in mind, licenses are granted to persons and they are non-transferable. So now this slide does make more sense, would be that as we look at the license types, these are the whats you could have. So you'll notice in the cultivation licenses, there's outdoor, indoor, and mixed light possibilities. And you'll notice that as you go up numerically from 1 to 3, the size of the operations become larger. You'll also notice some difference between outdoor cultivations, which are the type 1, type 2, type 3 license types that are all outdoors. The largest outdoor cultivation site you can have under the state licensing structure currently is 1 acre. You'll notice a note for a little further down in that column that says type 5, 5A, and 5B licenses. Those are larger than 1 acre in the outdoor arena. They go up to 4 acres. Those aren't available until 2023.
Mr. Bosanich, Supervisor Adam has a question.
Yeah, but that is not to say that 2 or more people can't piggyback onto a single site.
Chair Hartman and Supervisor Adam, you are absolutely correct.
Okay, thank you.
So you'll note the note right below the type 5 note line there says multiple licenses can exist on a parcel. Licensed premises must be separate and distinct. And so that's important to a part that identifies what Supervisor Adam just mentioned. Also of these types, the state's going to offer 2 different license types at the state level. One would be the A licenses. So for those would be for adult use or recreational or non-medical cannabis. and the Type M licenses, which are the medicinal licenses. At the state level, and again, this could be a model for us, doesn't have to be, but a model for Santa Barbara County may be that we would designate the difference between adult and medicinal cannabis licenses. Another option that this board may want to consider conceptually today is to give direction to staff about under what terms might licenses be denied, revoked, placed on probation with conditions, any other kinds of circumstances that would be allowable.
Supervisor Adam.
And to go back a little bit, as time goes on, the state's working on removing the distinction between adult and medicinal, right?
Chair Hartman, Supervisor Adam, I believe that to be true. I think at the end of the day, we will probably, within the next couple of years, have little or no distinction and allow, if there's going to be a tax differential at all in the future, but that day's not here today.
Right.
And in the state model, all the licenses are only good for 1 year and then would have to be renewed. Okay? So going a little bit further with the, so here's some examples of what this looks like in the field. At your top left there is the mixed light greenhouse type of growing operation. On the outdoor side, you have a couple of examples on the top right and also on the lower right. And then you have the pure indoor, which you think about it as a large commercial warehouse with purely artificial lighting inside. So just some pictures to give you a sense if you haven't been out to the sites before. Continuing with the state licensing types, and again, it's just a question, would you want to give us some kind of, general direction about do these things make sense for us here? The type 6 and 7 licenses are the manufacturing licenses. And these would be the folks that would be producing essential oils, other forms of products, including perhaps edibles, would be all qualified under the manufacturing license types. We're going to show you what some of this equipment looks like in a moment, just so you kind of get a sense of that. The type 8 licenses are for testing labs. They have to be completely owned separately. They can't own another kind of license and also be a testing lab. And they are the ones who are going to be required to test samples from various batches of final products, whether it's the flowers or the leaves or the essential oils or the edible products, anything else. The testing lab will be required to objectively identify whether or not the label placed on that by the manufacturer or the cultivator is accurate in terms of potency and ingredients. The Type 10 retailer license is probably the easiest one to understand. It really is about the sales and delivery to customers. It requires to have a permitted location but may operate exclusively as a delivery service. So there might be no customers walking up to that retail outlet, but they would be required to have one nevertheless.
Supervisor Wolf.
Thank you, Madam Chair. For the testing lab, Mr. Bazanich, does the person who applies for that license have to meet certain requirements, educational or otherwise certified?
Supervisor Wolf, through the chair, the regulations for the testing license itself are the same height, if you looked at the stack of paper, as all of the other regulations for all the different license types combined. So it's a rather extensive set of requirements of what qualifies you, and both from a physical capability in terms of the operation you have, as well as your own personal capability to run that testing lab. So I don't have chapter and verse here today about let's say the educational criteria, but we could find that for you. But they are very, very extensive requirements placed on those testing laboratories. Just continuing down the list, just so we're clear on all the different license types at this point. So Type 11 are the distributor licenses, and their main role is to receive product from either a manufacturer or from a cultivator, and they are responsible for providing the testing labs with the samples that they are brought into their warehouse. They provide those samples to the testing lab, hold the rest of the product from that batch until the results come back from the testing lab before releasing it to a retailer. And so this is an important quality control, quality assurance step in this entire product life cycle, is this role of the distributor in the system. And then one last license type are the micro businesses, and these folks are allowed to have a vertical integration but on a smaller scale than you would see with the other licenses. So the micro business license type, you're allowed to cultivate less than 10,000 square feet, but you can also act as a distributor with all the requirements of the distributor, including that testing requirement. And you could also act as a level 1 manufacturer, a non-volatile manufacturer of cannabis products, and also be a retailer, including the potential for delivery services, all in one. And again, it's all scaled down based on the square footage of cultivation. What's critical to think about in the go ahead.
Supervisor Wolf.
I'm sorry to interrupt, but I thought that there were certain requirements for the testing that it has to be separate from everything else. So how can a micro business include testing?
I'm sorry, it doesn't. It includes the distributor role,
Okay, but not
which
testing.
has to then send it to the tester,
Gotcha.
testing lab. So thank you for that clarification. The important thing to note in this system on the state level that I think does resonate perhaps for Santa Barbara County is that a licensee can only sell to another licensee or move the product to the next step. They can only transfer the material between other licensees. So there ought to be a very clear market that allows you to see that the product moves literally from a nursery to a cultivator, from a cultivator to either a manufacturer or directly to the distribution center. The distribution center has an exchange with the testing lab of the samples, and then the distribution center moves it on to the retail perspective. So ideally, that's the thing. So you can only sell to other licensees. Any diversion of product outside of that supply chain jeopardizes your license. Jeopardize your license. So the other piece that's important to note, so on personal cultivation, local governments can prohibit outdoor personal cultivation, but they cannot prohibit indoor cultivation. Vertical integration is allowed. Licensees can hold more than one license types with the exception of the testing labs. And currently in state law, the setbacks from sensitive receptors is 600 feet. And local government can specify a greater distance if they so choose. They could be larger than 600-foot setback, but they cannot be smaller. So here's some graphics of various things that we're talking about in terms of manufacturing. We've labeled these as either volatile or non-volatile machines that are available, including down here in the bottom right-hand corner, a press, some other extraction machines that remove the THC and the CBDs out of the product. And then in kind of the center right side there is a testing equipment that tests the cannabis samples or any manufactured products for the potency level of both the THC as well as the CBDs.
Mr. Bozanich, I have two questions related to this slide. The first is how big? We don't have a sense of scale, but is this large, take up the size of a room? Is it small, take up the size of a closet, a cupboard?
Chair Hartman, it's a great question. So I think one of the easiest ways to think about it is that image that's on the top left-hand quadrant of the slide with the 4 tanks, the kind of large green tank on the side. You'll notice that screen display right there in the middle. That's eye level. That would be an eye level display for the operator of that piece of equipment. So to give you that kind of a scale. The one immediately to the right of that that's labeled non-volatile, that's a desktop. It's sitting on top of a desktop.
And my second question is, I see the word volatile in it. I think fire or get nervous. Could you describe how these operations compare to other agricultural operations like lavender or olive oil or things that we're used to that we could understand this in light of?
Chair Hartman, it's a great question. So these machines are exactly the same as what you would use to extract lavender oil from any other kinds of flowers, other kinds of plants, plant materials, to remove those basic essence oils. And so they are no different, whether they're sold to do that for cannabis or for lavender or anything else.
So this volatile process is used already in lavender or olive oil or something?
Yeah, Chair Hartman, that's correct. They are currently used, and in fact, there's a regulatory structure on the equipments that, for example, that the state might allow, or that based, again, when the state comes out with its regulations, it's anticipated, and it was in the draft regulations, that any of these equipments have to come basically with whatever their version of the underwriter's laboratory seal of approval on them. And so there's an engineering company that does assess these machines for safety and safe operation. I'll also note that when you click on these ads for these equipment, all of the manufacturers of the equipment, of the manufacturing equipment, have training classes associated with it, so that they instruct people who are the operators in the safe operation of these devices. So,
Supervisor Wolf has a question.
Thank you. Speaking of, so are you saying that this testing is just like the making of lavender products? Or not the testing, but the manufacturing?
Chair Hartman, Supervisor Wolf, yes.
So even where there's this issue on page 9 of the board letter, flammable extraction, and I'm not familiar of how to make lavender products, but, and it's interesting because I don't know that we even have volatile extraction methods in any of our zones. So if it's, so I'm just curious if it's the same as lavender, why you folks didn't include it. And I would think that one reason is because it's stated here on page 9 that it's compressed and uncompressed liquid solvents using pentane, hexane, butane, propane, ethanol to make cannabis concentrate oil, post-extraction refinement, take in words that I don't even know what they are. So have you had the fire department, does the fire department, can they weigh in on this? Because honestly, that's kind of surprising to me.
So, Chair Hartman and Supervisor Wolf, and this is it's a learning experience for all of us, and it is very interesting to me as well. So one of the things I've learned about these systems is they are closed loop systems. So they're not venting butane out into the open environment. They use the butane and recycle that in order to recover the essential oils. So it's different than you think about. Heck, I grew up down the road from oil refineries, and you get them venting all kinds of materials at different points in the oil production process. These machines are closed loop, so none of those gases are escaping. They're recaptured, reutilized for future extraction operations. So in terms of the fire department, weighing in on those and putting those in the correct environment structurally and with kind of area around them for safety's sake, I think between the people who manufacture the machines and have identified the safety practices for them in combination with our fire department inspecting them, I think there's probably a high degree of certainty that they could be done safely. In terms of what's happening out there currently in the ag zones, let's say, where lavender oil perhaps is being produced either volatilely or through a volatile process, through one of these ones using a solvent like butane, versus the ones that are using a solvent like CO2, which are the non-volatile kind. I can't tell you from my experience what's happening out there, but perhaps Ms. Fisher, who's here in the room, might have some knowledge of that if she's available to answer that question about how much of that's happening here in Santa Barbara County.
And Supervisor Lavanino would like to weigh in too.
Well, I just wanted to say, there are illegal, volatile operations going on that are very dangerous to people that don't know what they're doing. And so, I mean, to me, obviously that's not somebody we would license, and they wouldn't be able to get a permit when we go out and inspect the equipment. But I think even, we've got somebody here from the Sheriff's Department also that has seen some of the operations that are out there that are illegal and can testify how dangerous they are. At the same time, there is a safe way to do it with the proper equipment. If it was in the zone, if it was in an industrial zoned area, or if it was handled properly. But I don't want you to get the impression that it's all fine and dandy, because with this operation of volatile extraction, if it's not done properly, if it doesn't go through the permit system and it's done on the black market, it can be dangerous.
And our Ag Commissioner Kathy Fisher
If I
is
could
here
just follow
too.
up, though. But am I correct that the volatile, that from your preliminary look in the EIR, that you're not suggesting any volatile manufacturing at this time? Is that right?
That's not my understanding, but did you want to answer that question, Mr. Bozanich, and then we'll go to...
I'd like to defer that to Mr. Clement if he would.
I guess I could just look at the chart right now.
Yeah, good afternoon, Madam Chair, Supervisor Wolf. That is one type of process that is being considered in some of the zones, and we will get to that later on in the presentation.
Oh, yeah, I do see that. Thank you. Yes, Ms. Fisher.
Chair, I apologize as far as the processing part of cannabis. I don't have any knowledge at all of the number that are out there at this point.
No. Our question was more to lavender oil or other existing processes that we have, we're familiar with. Are we using volatile manufacturing or processing methods currently, to your knowledge?
We do have one olive oil manufacturer, a grower and manufacturer. I'm not sure of the process they're using, but as far as your other examples with lavender, I'm not aware of any lavender oil manufacturing going on in a commercial setting.
In an agricultural setting?
Thank you for that.
There is an olive oil manufacturer, though, in the county, and we can find out for you.
Thank
on
you,
the
Ms.
process.
Fisher.
Thank you.
All right, good afternoon, Madam Chair, members of the board. For the record, my name is Dan Clement. I'm the Deputy Director of Long Range Planning. And whereas Mr. Bozanich was discussing the who and the what of what we're considering, this presentation now is going to turn into the where and the how, and that's more specifically having to do with land use, permitting, and zoning considerations. So as we've discussed at past updates to your board, we have not had the opportunity to go through the typical outreach process for this project that we would for other long-range planning projects that we're kicking off. It's been a very accelerated process, and one thing we did not have the benefit of doing was developing a project description that we could vet with your board and with the public first before we even engage with in the environmental review of that project description. So what we did when we were drafting the project description for the purposes of the environmental review, we took into consideration a number of things. So first off, obviously, we took into consideration the state regulations, because those establish kind of the fence posts of the regulatory arena in which we get to operate here at the local level. And then second, we also took into consideration what are the basic purposes and objectives of the zones as described in the zoning ordinance. This project does not involve any rezoning of land, so we're taking the existing zoning designations and we're trying to identify, given all the various types of cannabis uses, given the purposes and objectives set forth in the zoning code for these zones, where is it appropriate to consider allowing these sorts of uses in the zones? And then what complements that analysis is looking at, okay, what are we already allowing in these zones? That is, are there any similarly situated non-cannabis activities that are already allowed in these zones where somebody could reasonably say, hey, if that other use is allowed, it's reasonable to at least consider allowing the corresponding cannabis use in that zone as well. And I should say that these considerations go into any sort of zoning amendment project. This would apply to this project as well to projects that don't involve allowing cannabis activities or don't involve considerations of cannabis activities. Second, although we didn't have the opportunity to do that more robust outreach to develop the project description, we did conduct as much outreach as possible, and we received a lot of good suggestions, not only in response to the notice of preparation that we published for the environmental impact report, but then also as part of the updates and the workshops that we've conducted. And then also we've received very, very preliminary direction from your board as part of previous updates, and we've factor that into our consideration of what's being analyzed in the EIR. And then we're also taking a look at the cannabis registry data and to gauge where is it that people are considering or would like to conduct the various cannabis activities, and then what other information can we glean from how they are planning on operating their businesses for our consideration in terms of the environmental analysis and developing the ordinance. And then finally, and I think this is probably the most important consideration, is that we wanted to give your board as many options as possible. And as Mr. Bazanich described to you earlier, that can be anything from prohibiting everything that you're authorized to prohibit under state law to allowing as much as possible, given once again some of those other considerations that go into
Supervisor
developing
Wolf?
this ordinance.
Thank you, Madam Chair. I think this was one of the questions I had submitted on Friday, but I don't recall getting an answer. And that was after our last meeting, we had the proposed ordinance with all of the land uses. And now we have on page 13 of your staff report, potential zones. And it's different than it was originally. And so my sense is that perhaps after you received responses on the NOP that you modified the zones. And one of them that sticks out for me is neighborhood commercial. I think it was originally proposed and now it's not. So I'm wondering what other changes you made from public comments, and then my larger question, and will be something that I'm concerned about, is why you still continue to think that mixed use is an appropriate use for retail sales when residential is not. And if you made changes before, why didn't you include that as a change?
Sure, Madam Chair, Supervisor Wolf. So first off, to take the consideration of the CN zone, the neighborhood commercial zone, actually that was not under consideration in the draft ordinance that went out with the notice of appropriation, and continues not to be under consideration to be allowed. And the main reason for that was, if you once again read the purpose and objective of the CN zone, it did not seem to be appropriate to allow these sorts of activities. With regard to your second question about what changed, yes, some of the uses that were under consideration did change, mainly in response to feedback that we're receiving from the public on the NOP. So, for example, with regard to the mixed-use zones, initially some of the mixed-use zones were identified for consideration to allow certain cannabis activities, whereas others were not. But when we went back and took a look at the mixed-use zones, the purpose and objective of them, particularly in light of some of the comments we were receiving, we felt that it's reasonable to allow certain limited types of cannabis activities in the commercial portions of those mixed-use zones. So, for example, limited retail sales could be an appropriate use under certain conditions. And we thought, once again, that because it's falling within the realm of reasonability in terms of considerations, that we would throw it in just for the purpose of environmental review and to give your board the option of considering allowing it. But by no means is that a recommendation from staff that you should, or it's definitely not a statement that you must allow in those zones. So I just want to make sure that that's still clear.
Okay, so let me, if I could, Madam Chair, just respond to that. First of all, I do believe commercial neighborhood was in the original ordinance, but we don't have to worry about that issue. I think what's actually more important is that staff felt that now that it shouldn't be included as a place where dispensaries are allowed, so neighborhood commercial. But for some reason, staff believes that mixed use is okay. And honestly, from a rational thinking, I think I'm a pretty rational thinking person, it doesn't make sense that if you have, if you're outline all residential, but yet you're allowing mixed use where you have people living there and you think that's okay, but you don't think it's okay to have commercial, neighborhood commercial. It just doesn't make sense. So can you try and explain?
Could I first, I'd like to interject one thing. I don't think staff is telling us what to think at all. I think they're laying out a broad range, and in a further step today, we get to weigh in, and that will be controlling.
Madam Chair, this is my opportunity to ask a question so I understand the rationale. So if you can explain why staff made that decision, I'd like to understand.
Yes, and Madam Chair, Supervisor Wolf, first off, I want to make it clear this is not solely staff's determination. We did run this by, for example, the ad hoc committee, and there were a number of considerations. Also, we spoke with our environmental consultants who are analyzing these sorts of projects in other jurisdictions, and we've learned a lot. So we believe that if it can be justified, and I'm not saying you should or should not take a certain position on this. Your position, I understand, it's very reasonable, and if you decided to make a decision consistent with what you just stated, I completely understand that. So I'll make it clear I'm not arguing with you, or I don't object to what you're saying. But just in general, the logic was that if you can allow certain retail activities in these commercial areas in the mixed-use zone, and once again, under very specific conditions, controlled conditions, you could allow a similar type of cannabis retail activity in those zones, very similar to, for example, how alcohol is regulated in terms of sales in those sorts of retail areas. So
Where is neighborhood commercial located?
There's neighborhood commercial on Montecito, and I'd have to go check out the other maps to see where else commercial neighborhood zones occur. I will say this, it's fairly limited.
That's what I thought. I thought it was only in that one area.
I'd have to go check the maps to confirm that.
Thank you, Madam Chair.
So once again, factoring in those considerations that were shown on the previous slide, these were the zones that we identified as being under consideration for the allowance of certain cannabis activities. And in general, they are the agricultural zones, the commercial zones, mixed-use zones, and industrial zones. And the purpose and objective of each of these zones is stated in attachment 1 to the board letter. I'm not going to go through any of those as a part of this presentation, but if you have any questions about those, I'd be more than happy to at least attempt to answer them. And the zones are identified in attachment 2 to the board letter. And in general, the types of activities that are under consideration in these zones, starting with the agricultural zones, obviously it's cultivation, and that'd be all of the different types of cultivation that are identified in the state licensing types that the state will start issuing next year. We are considering allowing non-volatile and volatile extraction as accessory uses in the agricultural zones. And then distribution and micro business. And I should specify for the micro business, we're only considering allowing retail sales that are through delivery services. They wouldn't obviously be storefront types of retail in the agricultural zones. With regard to the commercial zones, we're looking at allowing cultivation, only indoor, non-volatile extraction, testing, retail sales, distribution, and the micro-business types of licenses in those zones. With regard to the industrial zones, we're looking at only indoor cultivation, both types of extraction, testing, only retail sales in the M1 light industrial zone, and that's because that is the only industrial zone that currently allows retail sales, and then also distribution of micro businesses. And then with regard to the mixed use zones, once again, as I discussed earlier, we are evaluating retail sales and non-volatile extraction to be allowed in there. Now, that's just identifying in which zones we're considering allowing the various cannabis activities. Another big component to this project has to do with developing standards of operation for these types of uses in the various zones, taking into consideration a number of factors: proximity to sensitive receptors, other types of uses that are currently allowed in the zones, and ensuring that the cannabis activities are compatible and will not interfere with those other uses. State licensing, once again, establishes the structure in which we get to operate when considering the various types of cannabis activities. And then the EIR analysis is very likely to set forth a number of mitigation measures that would be adopted as regulations in the zoning ordinance, and would be applied to zoning permit applications that we receive when we had checked to verify that the operations will comply with those standards in order to avoid the creation of significant impacts. And then there are a number of other legal requirements that apply, and these apply once again to all types of zoning amendments, not just zoning amendments that are dealing with cannabis activities. For example, when you're acting in your legislative capacity and to determine whether or not to approve a zoning ordinance amendment, you have to make certain findings of approval. So for example, you got to find that your action will not compromise the public health, safety, and welfare, and is in keeping with good zoning practice. And when evaluating the project in light of those standards, it very well could be that your board feels that additional standards above and beyond what the state licensing requirements will impose on these operations, and also some beyond what the mitigation measures set forth in the EIR would require, and what CEQA authorizes you to do. So with that said, our current schedule is summarized up here on the screen. Obviously, today we're giving this update to your board, and we are hustling right now to finish up the EIR. We're actually currently reviewing draft chapters of the admin draft of the EIR, and we intend to publish the EIR, if not within the next week and a half or so, definitely by the beginning of October. And we have scheduled a couple meetings, public meetings, during the EIR public comment period, at which the public can come and provide comments to us on what they're reading in that EIR. We're going to hold one meeting in Santa Barbara on October 12th and another meeting here on October 17th. And as Mr. Bozanich indicated earlier, we're also in the process of developing amendments to the Article 10 ordinance, which currently regulates cannabis activities here in the county. We presented those amendments to the County Planning Commission this month, and we intend to present those to you next month on October 17th. In November, as Mr. Bozanich mentioned, we're looking to come back to your board, provided that you invite us back, to provide us an update on the economic analysis and some of the tax options that could be considered in June 2018. And then starting in December and through February, we're going to be preparing the final EIR and preparing the draft ordinance amendments for both the Planning Commission's considerations in January, and then for your board's consideration in February. Provided your board approves cannabis activities in the county, we would then be working on developing a tax ballot measure starting in February in order to place it on the June ballot. And then for the coastal regulations, same with all coastal regulations, we need to get those regulations certified by the Coastal Commission. We estimate nowadays that it takes on average about 15 months to get through the Coastal Commission certification process. It could be shorter than that. We just really don't know. It's really up to Coastal Commission staff and their current workload. We have been in discussion with Coastal Commission staff already. We've given them a heads up that this is coming their way, and we will, to the best of our ability, try to hasten their review if or when that time comes. So with that said, the recommended actions are set forth on page 1 of your board letter and summarized right here, but we're recommending that you receive this report, provide direction to us on the conceptual licensing and zoning options that we described to you today. And then once again, to invite us back in November to talk about licensing and some ordinance amendments to other sections of the county code. And then finally, to find that this project, your decision today or your actions today are not a project under CEQA and are not subject to environmental review. I believe this concludes our presentation. Be more than happy to answer whatever additional questions you may have.
Okay, before we come to board questions, I would just like to ask, we have 28 people who would like to speak publicly, and I'd like just a show of hands if anybody's willing to speak for just 1 minute. I may have to bring it back to 2 minutes because this is the first time the board really gets to provide conceptual direction for staff to go back. So is there, how many people would be willing to speak for 1 minute? Okay, so when we get to public comment, I'll have you come up first, and I think it may be, I see about 5 hands out there, that you'll have to limit your comments to 2 minutes, those who follow, so that we don't get too tired up here and can't give this our full attention. So with that, bringing it back to the board, are there, I think what would be helpful is questions for staff and issues that we're struggling with that we would love to have additional public comment on to help enlighten us. Supervisor Lavanino and then Wolf.
Thank you, Madam Chair. And, I don't know if this is the appropriate time or not, but as a member of the ad hoc, and we've had an interesting 13 meetings. I know this has been a whirlwind, and it's been fast, especially planning standards go. And I would have much preferred that the state, in hindsight, had given us 2 years to implement this huge change to our land use, but that didn't happen. And so we've been working under this time clock. It's been ticking over us. I think staff's done an outstanding job to this point with what direction that they've been given. And I, for one, am willing to, I think it's time for the ad hoc to maybe disperse. And I think this is the better forum now to continue to move the project forward or not move it forward. So I think at this point, I think we brought this to as far as we can bring it. And I think at this point, it's really the policy questions really get to, this is the first meeting, I think, where we really need to decide who, what, when, and where all of this happens, or if it does happen. And so, I hope that as part of this, and I don't know if we had to put this in the motion or not when we get there, but that although staff continues to meet regularly, which I know you will anyway, but I think we've done what we can do with the ad hoc. One of the other things I know is, we've had people say that we haven't had enough public input. I went back and looked at some of the things that we've done land use wise, like the Gaviota Coast plan. That took 7 years and it was 130 meetings. And I think at the end of the day, there were still people that were opposed to it, that had been opposed to it from the beginning. So even if you had 130 meetings, you're going to end up, we didn't have 7 years or 5 years or 3 years to burn on this project. If we didn't act now, we're just going to have continued what we presently have, which isn't working. So, I don't have any questions. I just wanted to throw that out there too, so that the public knows that I, for one at least, feel like we've done our job of the ad hoc. I think ad hocs are supposed to only last 6 months or so anyway. So I just want to throw that for discussion for the board as well.
Supervisor Wolf?
Thank you, Madam Chair. I'm fine if you guys want to stop doing the ad hoc. I have been critical, but that doesn't mean I don't appreciate the fact that this is a really difficult topic that you both took on, and it has been a tight time frame, and you're also dealing with me in open session, because this, just because I have been critical. I've been critical of the process. And yes, we haven't had hundreds of meetings, but I do think that there is something to be said to have followed the process. Going through the Planning Commission. I know my Planning Commissioner had questions to ask, and she basically wasn't able to ask them and probably won't for another month. So I'm glad that we have the opportunity to ask questions, and I do thank you for all your work. So the one thing I want to say to our staff is I love the maps that you provided to all of us with our districts, and on top of that, the buffer areas. And that buffer is based on the 600 feet. Is that's right? Okay. So I think San Luis and maybe a couple other municipalities have increased it to 1,000 feet. And I'm sure we could do that. My question is, I've heard some discussion about how you measure that. Do you measure it from the center of the whatever it's like the school out to the location, or from the perimeter? Do you have any thoughts on that?
Yeah, Madam Chair, Supervisor Wolf, our reading of the regulations is that it's actually measured from property to property line.
Okay.
So the cannabis operation could actually be located on the property further than 600 feet from the sensitive receptor, depending on the configuration of where it is in relation to the property lines and then the other, where the sensitive receptor lot is located. So, and you are correct, you may increase that buffer beyond 600 feet, and that is one thing that's being considered in the environmental analysis, especially with regard to things like odors, because what you're going to see when you read the EIR is that, like odor control, it's very site specific given the specific geography of the site, and where 600 feet may work in one situation, it may not work in another. So you may need to increase those buffers in order to effectively address the adverse impacts from it.
Okay.
Just as an example.
Thank you for that. And I also understand that we could include additional sensitive receptor sites. Thank you for telling me what that's called, such as parks and recreational areas. Is that correct?
Madam Chair, Supervisor Wolf, that is correct.
Okay. And then I do have another question on the zoning purposes. Is it PI or P1? It's the professional institutional zone. The reason that I bring that up, it's particularly in my district. I believe that's, I believe it's hard to tell on the map, but it looks like it's right perhaps around the Page Youth Center or probation. Regardless of that, I think that that's an inappropriate zone to have any of these license types. It says in your attachment that professional institution is for educational, institutional, government, and other public facilities. So as we get to providing more specific impact, that would be one of my suggestions, along with the mixed use, that be eliminated. But can you tell me what the reasoning was, though, to include that? Am I missing something on that?
Madam Chair, Supervisor Wolf, yeah, the consideration that went into that was you had, in the professional and institutional zone, there are other types of research laboratories that are allowed. So we felt once again that given that specific license type, which as Mr. Bazanich stated earlier, if you are a license holder for a testing lab, you may not hold any other license. So you cannot have cultivation, manufacturing, any of the other types of cannabis activities. All you can do is take these samples, test them in a medical research sort of environment, and then provide the results back and then give it back to the distributor. That's all that's allowed. So we found that is very similar to, for example, testing labs that test agricultural products that have to be tested before they go out in the market. So once again, we felt it was roughly equivalent to uses that are already allowed in that zone. It does fit within the purpose and objective of the zone, so we felt it would be reasonable to at least consider allowing it in there.
Supervisor Adam.
Okay, well, what I want to do is kind of let my colleagues and the public know kind of where I'm headed and get somebody to tell me why it's a bad idea from one way or the other. I'm thinking about this in terms of allowing as much flexibility as possible and to inconvenience and annoy the least amount of people possible, because I know that everybody's gotten the calls about odor particularly, and then there's some of the other issues, and I think that this is the best way I've thought of to solve this problem. So what I would do is ban outdoor cultivation in all residential zones except as permitted by state law for personal use, cultivated entirely indoors. So if you want to grow your 6 plants at home or plants for somebody else, grow them in the garage, grow them in the living room, whatever, just not outside. Because it seems like outside production in residential areas is where we get all of our, or a lot of our complaints from. So I would prohibit cultivation entirely on all other zonings except those in ag zonings greater than 40 acres minimum parcel size. And what that's going to do is just get you completely out of town. And I know that that's not what the guys in Carpinteria want to hear, but I got a way to deal with that down the road here. Have a buffer of at least 500 feet from any existing neighboring dwelling unit from any production or manufacturing facility. So if you're out there on that 40-acre parcel and you're within 500 feet of an existing dwelling unit, not the horse barn, but the dwelling unit, then you got to back up a little bit. And all cultivation licenses, outdoor and indoor, available with those restrictions. Variances and CUPs should be available. If the guys in Carpinteria come up with the bomb-proof odor control, awesome. Let's permit, a couple and see how it goes. Type 6 and 7 manufacturing should be legal on all cultivation premises. Gets them all out of the urban areas as well. I would allow the testing on all industrial, commercial, manufacturing zonings. Type 10 retail, except no on-site consumption in all designated retail zones. Type 12 distributor license in the same zonings and size limits as cultivations. I do not support the micro businesses at this point because I think that these are going to be the hobbyist people, and they're going to be I think they're going to be the problematic ones, and I think that they're the ones where you're likely to get the explosions and stuff because they're not really experts. They're kind of maybe a large-scale hobbyist or something like that. I would also like to see us require business licensing that prohibits those with previous or future felony or misdemeanor drug offenses or DUIs from having a license and conducting business in our county. I would like to see us have an application process similar to that of the federal and state alcohol licensing process, wherein people are subjected to scrutiny of past behaviors and subject to loss of the license privilege if they break the law in the future. So somebody tell me why any of that's bad.
Well, we have plenty of speaker slips who will endorse or not. Supervisor Lavanino.
Thank you, Madam Chair. I just wanted to talk about buffers for a second and sensitive receptors. So if we had buffers and we have the 600 feet, any project that comes in and asks for a permit, we're going to be able to look at that individually. Because you said something the other day, Supervisor Hartman, that made sense to me. And every piece of property is unique. And so if you have, you don't want to put the most extreme buffer on something to start with, because if you start looking at the maps and you start putting these circles down where the sensitive receptors are, and if you started adding sensitive receptors, you end up with an effective band because there's nowhere to go because it's all band. There's a sensitive receptor. So would you be able to put something like 600 feet, but then condition a certain project when it comes in with a permit to be able to say, in your particular area, it's going to be 1,000 feet or it's 1,200 feet?
Madam Chair, Supervisor Lavigno, I believe that's possible. You just want to make it clear what is the criteria you're using when making that evaluation.
Okay.
And I should state that, let me back up. One thing about the chart in the board letter, you'll notice that we did not specify what type of entitlement will be required for the various activities. We are envisioning, though, that all these types of activities would require at least a land use permit, not a, for example, ministerial zoning clearance, so that we could take into consideration site-specific characteristics and condition a project appropriately.
Okay. And then the license being coming back every year. So you've got somebody that's a bad actor, instead of you being married to that project for life, they come back every year, and we have the, is it discretionary thumbs up or thumbs down on the business license?
Chair Hartman, Supervisor Levanito, that would be the intent. That's the way the state's operating with their business licenses as well.
All right, great.
Madam Chair, I just want to point out something with regard to those maps with the 600-foot buffers. Those don't show all of the buffers, and that is all of the sensitive receptors in the county. Those are just based upon the GIS layers that we have easy access to. For example, we have easy access to all of the licensed daycare facilities, all of the schools, but there are other types of receptors and areas that would qualify as youth centers that would also be subject to buffers. So in other words, those buffers are not the entire universe of buffers that would exist provided you allowed cannabis activities in the county.
Mr. Gazzoni?
Chair Hartman and Supervisors, I'd like to just bolt on to that answer that as the board is contemplating different zoning regimes, we really have three different concepts that touch each other. The first is uniformity, which we've discussed at a prior board meeting, and that is that zoning regulation should be generally uniform within a particular type of zone. We have spot zoning, which is a prohibition against having a parcel have less rights than a surrounding property, and that's related to an equal protection item. And then all of this goes to the area that it's actually easier to provide relief or more legally defensible to provide relief from a standard than to tighten the standard in a particular neighborhood. And that's really the essence of what variances are. When a property would be deprived of uses that are allowed to other properties based on some unusual circumstances of that property, that would be a variance. So much as we've talked before in marijuana, that it was more defensible to start with the valve closed and then open it up and allow uses, so it is easier and more defensible to have clear regulations and provide relief of that through variances than to try and tighten them up case by case.
Supervisor Williams?
Well, I wanted to correct one thing. CN is not just in Montecito. CN is in Orcutt. CN is in Gary. CN is in San Ynez and Los Olivos. So it's not like staff is just making an exception for the Upper Village. The other, I know there's this, the talk, the question of buffers. I am personally a little, after you draw enough of these circles on the map, it's pretty easy to get to a de facto ban in much of the county. And I just think that bans are, as shown, pretty unenforceable when all you have left is zoning enforcement power, because you have the capability of closing down, a handful a year. And we got 250 businesses out there. So how many years you want to wrestle with this is kind of, that to me is really the practical question about it. I think some of your suggestions are really good. I'll put right out there that I really strongly agree with the idea, and I think it's a great idea that no convictions is for license crime. Of course, to me, that you would add that to what we already were thinking about at the ad hoc, is that you can't have felons in general working for you. That would be the reason you would fingerprint people. You wouldn't necessarily just fingerprint them just for the sake of having them go through the bureaucratic expense. You're fingerprinting them to make sure that there's not they're not a felon when they apply for the job. I think this question of how to handle the 6-plant thing is a pretty important question, and you bring up one solution. I will point out what is the possible problem with that solution, which is just fire risk. Amateurs having lights, high-powered lights going 24/7 has some issues, I don't like that the state has not given us much discretion in the personal grow amount, but I'd almost rather have them outside than posing a fire risk.
Supervisor Wolf?
Thank you, Madam Chair. Well, one advantage to being really old up here is that I remember that you couldn't have any plants in your house, and it was a misdemeanor, and people were afraid of growing plants in their house, or in their apartment. So I fully support Supervisor Adam in this. If we're worried about fire with people growing marijuana plant in their house, I think we should also worry about fire in a volatile manufacturing situation. I'm so concerned about that.
You want to put that out in the hinterlands, too.
I just want to comment on, one thing that's just really striking to me is that Eastern Goleta Valley is an incredibly dense urban area, so it's unlike any other district, although I think every district has an urbanized core. And, I don't think that if you were to extend the buffer by 1,200 feet, you would necessarily totally ban. And I don't think we should necessarily look at things like that. I think what we should look at is neighborhood compatibility. And all of the meetings that we had in Eastern Goleta Valley had to do with neighborhood compatibility. That was one reason why we wanted to preserve our ag land, our very small amount of ag land for family farming. That was the other reason why we agreed to mixed use. I think there were a lot of community members who were not so clear or sure about including mixed use, which was going to give us 177 or 180 more units. I was concerned about that, but we were reassured that when you go with mixed use, the commercial area is going to be compatible with the residential area. So these are the concerns that I have. I think extending the buffer to 1,000 feet is reasonable. Yes, it may cover a lot of the urban area, mainly because we do have so many schools, and we have a lot of preschools, and we have a lot of pocket parks. That's the nature of the community. And so I think to the extent that all of us would want to ensure that our community integrity is maintained, I think to the extent that we can do that, we should do that. And that's really what I think, what I want to do, and what's important to me. Thank you, Madam Chair.
Good. And what I'd like to do is maybe we would continue no longer than 2:30 with board comments. We're not into deliberations. We're just trying to kind of flag some of the issues that are important to us. Then we'll go to public comment, and then we're going to come back, and Mr. Bozanich is going to walk us through so we can indicate our conceptual direction for staff to pursue. So, Supervisor Adam?
Well, I was just going to answer the fire comment. Like everything else, I get people all the time telling me that their broccoli doesn't turn out the way that it looks at the store, and I always tell them that's because professionals grew it. And so, I think that having the amateurs growing stuff at home never turns out right, and they'll probably just end up buying the stuff from the professionals anyway. So, if somebody wants to have their 6 plants in their house for a little while, then they could do it. But, all of the calls that I'm getting our external production in the, I haven't had the fire yet. We've only had lots and lots of calls from disgruntled neighbors for a variety of reasons, not only, and Mr. Olmsted will back me up on this, nails, just an unsafe condition in a fence from people trying to exclude people from coming over into their house or into the backyard and stealing the stuff. Just the traffic issues that come with these outdoor grows, which are arguably for personal purposes. They get so big, you got to wonder, why are they growing this many plants, and do they really have this many friends? And so it's just something that's very difficult to deal with. And so I think this is just a threshold issue, is banning this outdoor production in residential areas and getting it out into real commercial agriculture areas where the professionals are going to do what they do in a professional way. And I think in the end, that's going to be what that the kind of the rules of engagement in this thing. As the volumes go up and the prices go down, I think you're going to see the only ones remaining in the end are going to be those larger producers that are doing it on a really efficient basis anyway. So I would design it so that there's not a whole lot of people that are going broke.
Supervisor Lavanino, then Williams, then me, then we'll go to public
Great.
comment.
Thank you, Madam Chair. And I think on the going back to setbacks for a minute, we haven't even really seen what the EIR has shown us yet. So, I wouldn't want to make, I understand, we can throw a number out there. It's always interesting whether it's 600 feet that the state says, or we just decide. I don't know why we wouldn't think 750 or 1,000 or 1,500 feet. We don't know. So let's take a look at what the EIR says. For me, 600 feet is the state law. I think the more compatibility we have with the state law, the easier it is going to be to enforce things. And for me, personal cultivation outdoors, I just assume, I'm not a big fan of that either. I mean, it's in residential most of the time, and I'm not a fan of that. I think it's kind of, though, I think like exactly what you said, it's kind of like the stills of the old days. How many people are still going to be around making their own, you can go down to 7-Eleven and buy a beer, so. Yeah, exactly. I would like a little clarity on item 4 there, conducting any operation without a county and state license and land use permit is a misdemeanor. We talked about this in ad hoc, but it really hasn't been discussed in this meeting. I think it was a really important point.
I didn't know that we were on.
If somebody wants to discuss enhanced, so instead of just a land use permit problem, you've got actual criminal penalties.
So, Chair Hartman and Supervisor Lavanino, as you'll recall from the conversation at the ad hoc committee, and for the rest of the board now, as well as for the members of the public, the thought there was, do we want to really have more significant consequences than just simply the land use fines that now, pending the governor's signature on AB 566, thank you, Glenn, are $100 per violation. And so would we consider looking at misdemeanor? I believe that was still under advisement with council at this point.
Right.
But the thought would be with a misdemeanor crime, we would perhaps be able to do confiscation of equipment and as well as the product.
And I am in full support of that. I think that's something that, to me, that's been the biggest problem that we have right now, is we just don't have a tool in the toolbox to deal with this, and make it criminal instead of just a $100 fine would be a huge improvement. So I would support that as well.
And Mr. Gazzoni had some more to add to that.
Chair Hartman and supervisors, in the area of misdemeanor versus infractions, our starting point is that code violations start off being infractions unless otherwise designated in the land use code. And this is an area where maybe staff could also consult with the district attorney's office as to workload or delay issues. Although there's a more substantial enforcement with a misdemeanor, it comes with some overhead also in terms of potential jury trial. And we've had that discussion before on other enforcement avenues. The other point, going back to Supervisor Adam, at one point he put up on the slide the licensing as to people with convictions, and state law already addresses that in part as to the state licensing authority. So there is some paper has been written on already under California Business and Professions Code 26057, which lists a group of offenses that would preclude a state license. So there is something written on that already.
Supervisor Williams.
Again, because I already live with this, incredibly nearby in Carpentry, I have some observation, which is that I think this discussion of buffers isn't as important as where you mandate odor control, right? Because that's the primary nuisance of the mixed light, or outdoor cultivation. And so I would say that I don't think we should do that additional buffer that you proposed, but that we should mandate odor control devices as a requirement of the permit within some specified distance of residential neighborhoods. Whether that's a mile, 2 miles, I don't know. I think that we should talk about that if people like that idea. But to me, that's sort of a basic thing, is that they're going to have an impact. Even if they're outside of that buffer, they're going to have an impact if they don't have decent odor control on their operation. So I'll put my 2 cents in that, and the conducting any operation without a county and state license and land use permit absolutely should be a misdemeanor. I also think that we should, on any indoor operations, have additional permit requirements, like use of a state licensed and apprenticed electrician to do the electrical to mitigate fire risk. Maybe solar to mitigate the incredible energy and demand that those operations do. Particularly when you're talking about stuff that isn't personal use, those indoor cultivation, just huge issues on both of those fronts.
Our time up here is quickly running out, but I see some more lights. But I just want the supervisors to know we're going to be coming back to this chart. So it isn't your last time, but we're just trying to capture everyone's ideas here. So Supervisor Wolf had something, then Supervisor Adam, then me, and then we're going to public comment.
So I guess I'm a little, the 600-foot or greater setback from schools, that's what we're talking about, the sensitive receptors, correct? Okay. And is that what you were referring to, Steve?
Yeah.
Okay. So so this is where I got the 1,000 feet, and I got it from, of which Dr. Dean is actually a director, California Conference of Local Health Officers. Their recommendation is 1,000 feet from sensitive receptors. And I'm not sure if I mentioned this before, but San Luis Obispo also is using 1,000 feet from a sensitive receptor. So that's just to answer that question. And then I think there's nothing in here that asks us to talk about what zones we would prefer to not have any activity. Is that right?
That's coming, right?
Is that coming?
Yes.
Okay. All right. I think I'm done for now. Thank you.
Okay, I'm just interested in Supervisor Williams' idea. Were you talking to me when you said my buffer?
Yeah, the buffer from residences would be 500 foot from the dwelling.
That's out in the 40-acre parcels.
I think that's not how they wrote it. That isn't how they wrote it up here. It's a 500-foot buffer from anywhere.
From a
Any existing dwelling on a AG2 parcel greater than 40 acres.
Without putting that, Peter, that's essentially a de facto ban for most of the county.
Well, no. No, actually, probably most of the county is okay. And see, I don't know where you would get, how you would get odor control in an outdoor grow.
No, that's
You're just not
that's
gonna
true.
get that.
Now that I understand what the 500 buffer that you're proposing.
Right, that's why I wanted to clarify that, because,
No, my odor control requirement idea is particularly, I think, important for places like Carpinteria, where there's a close proximity between agriculture and residences, even though some of those residences are not in residential neighborhood.
right,
So-
but even those, and I'm thinking Santa Rosa Road, where you're out there on the 40-acre plus parcels, there are existing grows with existing neighbors that need to have some consideration. And, if you're going to go out and build a new house right next to the grow, then I don't feel sorry for you because it's there. But if you're not going to build a new house and the grow moves in next to you, then they need to have some buffer included for them.
Got it.
Okay, I have 4 major points. It's sort of big picture where I'm coming from, and maybe people have additional ideas of how to get there. The first thing that's really important to me is strong enforcement, and that is that we have a system in place that gets after the unlawful grows up in the forest, for example, and unpermitted, so that we bring people into the regulatory system. And I agree with Supervisor Lavanino that probably to the extent that we can get our county regulations in line with the state, it'll make it easier. I very much favor, I think, both a license and a land use permit for reasons that have already been discussed. And then all these nuisances are critical to address. And part of that will be where we allow the licenses, and others will be what kinds of standards go with them. The second point is, for me, it's very important that we capture value here in the county. So that, to me, suggests that processing or manufacturing, however those terms are, I think how we use it generally and how they use it in state definitions is a little different, but that we add value and get the revenues that are associated with that. I think it also suggests that vertical integration is a good idea so that our farmers here can capture the value. I would like to see the registry people who came forward and who've been here cultivating medical marijuana, that they get preference for permits. And that was one of the things we said with the registry, was that it might be that they get first in line, and I would like to see us follow through on that if that's possible. I am thinking a cap isn't a bad idea, or a cap plus. And again, it would give favoritism, or to the extent allowed by law, to our local people who've been here. It would also provide an opportunity for us not to have to swallow a cow all at once, that we can take it in little bits. To capture value, I'm very much interested in encouraging laboratories, testing laboratories to locate here, and I know that's a huge capital investment, but I would like to see the county be proactive to whatever extent we can to make that happen. The third point has to do with restrictions, and I'm very hesitant. I think Ag 1 properties in my neck of the woods, the Santa Ynez Valley, those are residential properties, and outdoor grows in Ag 1 properties, I don't think that's appropriate, at least in my area, but I understand that in Carpinteria, where it's within greenhouses or within warehouses, that's a different matter. I'm also thinking that mixed use is not an area where we should. I'm eager to hear more about microbusiness. I'm persuaded by what I've heard Supervisor Adams say. And I'm also very concerned about Tepisque or high fire areas. I know fire isn't necessarily associated so much with where that's almost like national forest lands, very wild, it raises, I think, singular issues that we need to address. I would also like to find a way to, when there are sustainability practices where water is being recycled or where they're using existing infrastructure, that somehow get a benefit in the regulatory system that we develop. The final point I have goes to process. This has been a very intense process, and I'm grateful for the ad hoc committee and all the department people who've been working cross silos to address these issues in a coherent way. I think while it has been a very condensed process, it hasn't been a rushed process, and I think people have, that to some extent, there's an advantage in how much intensity there has been. You don't forget it, and people, it's foremost on people's minds. I would support, however, at this point, dissolving the ad hoc committee. I would, however, like to see the Planning Commission brought into this. I think we would have benefited to have more. They really know a lot about zoning and land use issues, and so I would encourage in the process as it goes forward to have more Planning Commission hearings and allow them to take part. So with that, yes, Mr. Klein.
Madam Chair, I know time is of the essence. Just two really quick points. With regard to your last suggestion, what I failed to mention in the schedule is that we are already planning on returning back to both commissions for further updates, actually next month, and then if we can squeeze it in before the January hearings, we'll try to do so, but the schedule's getting tight. And I just realized, Supervisor Wolf, where the confusion came from the original ordinance amendments that were published with the notice of preparation, because if you go to, just for the record, it's on page 13 of the draft ordinance that was included as part of the NOP. It's table 214 under cannabis retail. There's a column for the neighborhood commercial zone. And then if you look at what type of permits allowed for retail sales, it has an S. And that directs you to the special use regulations that are set forth on page 30 of the draft ordinance. And if you go there, what you're going to see, there's it is not allowed. So you got to follow the chain all the way to the end. So it's always been the case that it has not been under consideration. But I completely understand if you're just to look at that first table, why it may present confusion. And it's great because then we can clarify this when we actually draft the ordinance, if that is the direction we're given from the board. So I just want to clarify that point.
Okay, and with that, I would like the people in Santa Maria who are willing to speak for just 1 minute to start lining up on the side. And then it's important that you say your name clearly because Ms. Alexander has to find your speaker slip and take it out. And then we'll go to Santa Barbara for the people who are also willing to speak 1 minute. And now you've had a pretty good sense of what some of the issues are for us up here considering this matter. So if, to the extent that you can address your comments to some of these concerns, that would be very helpful. Okay, let's start with just come up and announce your name, and that way Ms. Alexander can take your speaker slip out.
Hello, my name is Derek McLeish. First of all, I want to thank all of you, Chairman and Supervisors, for the rigorousness of your approach. I didn't know this was happening, so I really appreciate it. And I do think we have a once-in-a-lifetime opportunity to, as policymakers, to change from a black market business to a clear business. One of the biggest potential problems that we have is we don't have enough revenue generated by this to really enforce what needs to be done. And right now, the county does not enforce laws against lower economic targets. So I think you need to build more enforcement dollars, more revenue into this whole process. Otherwise, during this process, the black market will be just like Mexico. It'll flourish again. The black money is already coming in. It's buying properties, it's buying votes, it's buying supervisory lobbyists. It's buying all sorts of things with black money, and that black money is buying properties. So you need more revenue.
Thank you.
Good afternoon, Supervisors. My name is Gene Malone, and I'm from Sabata Canyon. I retired from law enforcement after 27 and a half years, and I think that the county and the state has made a huge mistake.
Could you speak a little more into your mic just so we can get...
That being said, I bought in Sabata Canyon 18 years ago. I bought 20 acres. I have my horses. I expected fresh air had a good time. Recently, I've discovered 10 illegal grows in Sabata Canyon. I've got increased allergens from that. I've got rashes from that. I get migraine headaches. I get more headaches. No one's brought that up, that this is causing other issues besides just, it's this far away from me, you should tolerate it. Excessive water use, I could go on about that. But I agree with Supervisor Adam, if you're going to allow grows, which I'm against, but if you're going to allow them, please make them on parcels larger than 40 acres so that I'm already surrounded. I bought a place, I had horses all around me, now I have grows all around me.
Thank you. And we did get your email into our record, so thank you.
I do appreciate that.
And that is your time, however.
Okay, thank you very much.
My name's Paul Goforth. I'm in Tipsgay. I'm computer illiterate by choice, so I like to do things the old-fashioned way by paperwork. So I would hope that it's going to be one-stop shopping for the licensing and all this kind of stuff in regards to the rights. I'm a landowner, and I don't believe anything I'm hearing out there, so that's why I'm here to find out that, make sure it's correct. I agree with what Mr. Adams says. I agree with this gentleman here. He is my supervisor, and any problems in Tipsgay Canyon, I know they can be wiped out if the right people get together and talk about it. Thank you.
Thank you.
Can I have this 13 seconds on top of that? I'm going to go very quickly here. My name is Stephanie Keenan. I am a mother, a wife, and a cannabis farmer. I am also a kidney transplant patient, and I have cannabis to thank for helping me avoid dialysis treatment while waiting for my transplant. I would like to circle back to introducing myself as a farmer. 2 meetings ago, I was leaving one of these meetings, and I overheard a woman saying to someone while looking me dead in the eye, "I can't believe they call themselves farmers." We call ourselves farmers because we work 10, sometimes 12-hour days in dirt to produce a crop that will hopefully pay the bills and put food on the table. Because of the way we farm and nutrients we use to produce a high-quality boutique-style product, our overhead is quite high. We have enough to pay bills and put food on the table. I feel various counties have delusions of grandeur when it comes to taxation, and I come here in hopes of fairness. Yes, back in the day, money was flowing, but it is no longer like that. It is difficult, and it is not an easy life. Similar to most farmers. I also grow wine grapes, and I will tell you cannabis farming is far more difficult. So please treat us fairly and let the smaller farmers like us stay in this with fair taxation. And also please let us cultivate on parcels smaller than 40. I'm on 26 acres in Buellton. I do not farm there. I farm in another county.
And that is your time.
Oh, darn
Thank
it.
you.
Okay. You got the gist.
Hello, my name is Seamus Etheridge. Madam Chair, Supervisors, I really appreciate all the time and effort you guys have put into this, everyone else involved as well. I've been cultivating for over a decade in Santa Barbara County, what I consider legally, medicinally. I really would appreciate that the good operators that were here before January 19th obviously get a little bit of leeway as far as being first on the list. The other thing that I would say is try to follow the state laws as much as you can. I think it's going to be easier for everyone. The cannabis conviction, or the conviction and license, unfortunately some of the professionals that you would call professionals have convictions for cannabis in the past. So I would hope that that might be something that might be overlooked as far as the convictions for licensing. Other than that, try to do all of the licenses that the state is going to allow, and volatile extractions can be very safe when done properly and should be allowed in the county.
Thank you.
Thank you.
Hello, board. My name is Brian Adams, and I wanted to speak to the ways that you guys are considering buffering and acreage. And frankly, if you've got a 100-acre parcel or a 20-acre parcel, if you locate it on the back of the subdivision, you're not mitigating any of the same issues. So simply taking it as a size of parcel, I don't think addresses the problem. the 500 feet from an auxiliary dwelling, like a neighbor, for example, not your own if you so choose, is probably a reasonable way to look at it. But simply taking 40 acres versus 100, I don't necessarily would know that would fix that particular issue. Second, I wanted to thank everyone for allowing the supply chain. So not forcing a cultivator in Santa Barbara, for example, to rely on someone in Los Angeles allows us to actually do business, allows us to control maybe our sales channel or control our quality, retailing, branding, and things like that. And lastly, I'd ask for consideration to what the microbusiness actually is. So it's for lack of better terms, a winery type of location where someone could produce something, produce an edible, and supply it to an end consumer. And I think that's something that we stood behind in the wine industry, and we deserve the same opportunity for. Thank you.
Thank you, and thank all of you in Santa Maria who agreed to speak just for 1 minute. And let's go to Santa Barbara and see what speakers we have there who are willing to speak for just 1 minute.
Madam Chair, members of the board, Sam Ramirez with SEIU Local 620. Let me thank the Doobie Brothers and the ad hoc committee for all their work in trying to address this issue. All we ask is, as the board moves forward with deliberations on smart policy and smart politics, is that they not over-regulate this industry. As Supervisor Lavagandino and Supervisor Hartman mentioned, I think it's best to kind of mirror the state's regulations. It's an industry that we know is going to be regulated, and I understand that it needs to make sense for Santa Barbara County, but the goal, of course, of trying to regulate this is to also bring in revenue and bring sources of funds that help address the county's budget, and over-regulating it drives it underground, and it doesn't accomplish what I think that we all want to accomplish. So just want to bring those comments to the board. Thank you.
Dewey, oh good.
Hello, my name is Marcia Mendoza, and I am a resident of Carpinteria, and my concern is the odor that is permeating into my neighborhood due to the growing of the nurseries around my area. I was glad to hear that Supervisor Williams is aware of that and mentioned something about mandating the odor. I'm also wondering if anybody's doing any studies on how this affects people with allergies and asthma. I seem to be using my inhaler a lot more lately, so I wanted to piggyback on that one lady that was worried about her allergies, and I hope you're doing a study on that. Thank you.
Ms. Mendoza, how many people are in Santa Barbara for 1 minute?
Sorry.
Oh, could you tell me, are there others there in Santa Barbara who want to speak for just 1 minute? Can you look around and tell me?
Anybody want to speak for 1 minute? No, they want 2.
All right, thank you so much. Well, while we're in, how many speakers do we have in Santa Barbara? Let's go then with our Santa Barbara. Well, we've got the camera. We've got 5 speakers, so let's hear you first, and then we'll come back to Santa Maria.
Chair Hartman and members of the board, we're going to begin with Cody Hema, to be followed by Robert Bjorklund. Cody?
Hello, my name is Cody Hema. I am the Chief Operating Officer of Maria Ignacio Farm Collective Incorporated. I have been heavily vested in my Farm Collective Inc. since 2009. From what I understand of the presentation from the Sub-Hop Committee, we wouldn't be able to grow on our premise due to the zoning. Since 2009, we have been investing time, money, and effort into our collective under the assumption that would be a big part of our lives and livelihood into the future. Working with members to best suit their needs, gardening and education, working on our inner structure to support the garden and collective, including security, fencing, irrigation, self-education, learning organic and sustainable farming techniques of our area, and also forming a nonprofit corporation. I get a salary that I depend on. Also, we have been learning the complicated tax code for cannabis and following it, working with the California Cannabis CPA to do it right. Not only myself, but a lot of other members have invested huge amounts of time, money, energy, and love into this established collective. All of these statements can be substantiated with documentation at the board's request. In closing, taking our ability to operate as we have historically done would create a huge financial loss for myself and many collective members of our close family, but the biggest loss would be for the qualified patients, and that's growing organic, high quality, and affordable cannabis for the qualified patients of Santa Barbara. Thank you.
Our next speaker is Robert Bjorklund, to be followed by Anna Carrillo.
Hello, my name is Robert Bjorklund. I am the owner and founder of Maria Ignacio Farm Collective. At 9 years old, we are the longest operating collective in Santa Barbara. I'm here today because it seems as if our collective will be a non-permittable due to possible new zoning. However, according to Santa Barbara Owns County Section 35-1003, Prohibited Acts and Exemption, Number 2, Legal Nonconforming Uses. Exemption, medical marijuana cultivation, locations already existing on January 19, 2016, if they are legal. Under California state law, these would become legal non-conforming uses. I feel like this is getting pulled out from underneath us like a rug. Additionally, our property is surrounded by avocado orchards. Our property contains olive orchards that were planted over 100 years ago, and since my grandfather purchased the property back in the 40s, Robert Hyde, we have always covered our property in trees and plants. According to subsection 35-1003A2 of the medical marijuana regulations, we would qualify for a legal non-conforming status, not only for cultivation, but for the location as well, as stated above. On November 1st, 2016, we were fully inspected by the County of Santa Barbara to ensure that we were in compliance to those regulations by 3 county personnel, the top personnel, by 2 fire marshals, and 2 head of narcotics. No violations were cited. In closing, the obvious solution will be to give to us a legal non-conforming status, not only for operating, but for zoning considerations the board decides on, for any zoning considerations.
Thank you, and that is your time.
Thank you very much.
Our next speaker is Anna Carrillo, to be followed by Barbara Close.
Hello, thank you very much for this opportunity. I'm Anna Carrillo. One of your jobs as supervisors is to protect specifically Carpinteria's quality of life and its residents. We have neighborhoods, as everybody knows, surrounding the greenhouses, and they've been there for 30 to 50 years. So greenhouse operations have been there also, but because of the odor, it's been very difficult to continue to, live there. I know the superintendent for Carpinteria has written a letter requesting that you consider a 1,000-foot, buffer. I think sensitive receptors, I think neighborhoods that are along that foothill and foothill road specifically should be also considered for the sensitive receptors, and I think there needs to be a minimum also distance, I would like to see 1,000 feet. I don't know about that. And then this odor control needs to be not only a mandated thing, but it has to be checked and verified, and maybe like the pest control, where they check every month on the pest control, because I understand you can have it, but if it's not checked regularly, it doesn't do any good. I agree with the county's 3-part licensing and permitting system. I don't think we should have any commercial outdoor grows in Carpinteria, just because of the nature. There's no way to control the odors that would be there. There'd be additional security. And we're having, and the Ag 1 parcels and the Ag 2 are just, they're neighborhoods that are set in there, and so that's always, very, close. And I think this 6 plants is a real problem, because if someone rents a house, what does the homeowner, does he allow the 6 plants to be grown, indoors? Does he have to be notified as a landlord that someone's growing, the plants inside, his house? And we have a reputation as a small beach town, and that must be preserved and not be allowed to become known as a cannabis growing community. Thank you very much.
Our next speaker is Barbara Close, to be followed by Sally Eage.
Good afternoon. My name is Barbara Close. I'm one of the leaders of the Eastern Goleta Valley Coalition. And I just want to start out by saying that that the people that are on the cannabis registry were not notified of the change of the time today. And so I think you received inaccurate information about that, because myself and many others did not receive any notice about that. I don't believe that in the recent history of the county or the state there has been anything quite like this issue with such intrinsic potential for harming our communities. My concern in coming today was to request that the ad hoc committee be shifted to the full supervisory board, which I support happening today. I have attended most of the public meetings as well as the Planning Commission meeting a week ago, and I can tell you that the information being presented by the county staff is selected and limited in its scope and depth, which is one of the reasons why I really support the supervisors being in on the rest of the process. One area of particular concern is how regulations will be enforced. Consider the Carpinteria and Tepesquay areas where people's lives are being wrecked with no help for them in sight. And we're thinking of adding more cannabis to our lives. I do support a prohibition on outdoor cultivation in residential areas. I think that the risk of fire is very small versus all the negative impacts and complaints that we are already hearing from people that are growing outdoors. And I think enforcement will be much more difficult. I have not heard any citizens from the neighborhoods other than those in the cannabis industry request that they want the industry to flourish in their part of the county. Therefore, I am strongly requesting that the supervisors act to ensure that the cannabis initiative is completely vetted and that the public is fully informed and protected against the fallout of inadequate and incomplete planning. Thank you.
Our next speaker is Sally Eage, and then after Sally, we're going to come back here to Santa Maria for Lil Clary.
She had to go. She's gone.
Alrighty, we are going to come back here to Santa Maria for Lil Clary, and then to be followed by David Glory.
And I would ask the second speaker on deck to get in line so we can not have to waste time waiting. Thank you.
Thank you. My name is Lil Clary. I represent the Tepesquay Canyon Crisis Committee. We are opposed to the permitting of medical or recreational cannabis activities in Tepesquay Canyon. Our experience with the numerous illegal grows we are dealing with demonstrate how incompatible these are with the canyon's environment. We therefore request that the county prohibit commercial cannabis operations in Tepesquay. Tepesquay is appropriately zoned Ag 1 and Ag 2. But applying these zoning categories to permitting cannabis county-wide does not reflect our unique historic agricultural uses, scarcity of water, safety and capacity of existing roadways, and definitely our extreme fire hazard. I think I've spoken before and mentioned that we are in the state-designated highest fire category. The county is able to approve or deny locations of commercial cannabis. You don't have to justify or explain. But I would point out that there is a mountainous zoning which is applied to Gaviota, Goleta, Toro Canyon, where according to the scoping document that we were provided, marijuana operations will not be permitted. Mountainous employs the definition slopes in excess of 40%. That's certainly the Tepesquay corridor from Santa Maria Mesa Road up to Highway 166. Further, and I'm quoting from that document, the intent of the mountainous zoning is to allow reasonable but limited development because of extreme fire hazard, minimum service, and/or environmental constraints. Thank you very much.
Our next speaker is David Clary, to be followed by Hunter Jameson.
My name is David Clary. I'm a retired attorney, lived in Tepesquay Canyon for 20 years. I'm going to follow up on what my wife said just now. And I have to wing it because my 3 minutes I find impossible to really condense. I hope I can submit it in writing later. But anyway, I was asked by a neighbor to look into the possibility of any kind of equal protection issues regarding Tepesquay Canyon. And I think there are some, mainly the issues that my wife raised, that the mountainous zones, Goleta, Toro Canyon, and Gaviota, there is no cultivation, period, allowed in those canyons and I mean in those areas. And as my wife said, if it's a mountainous area, one of the requirements in those areas, it has to be mountainous over 40% grade. Well, my house is 600 feet above Tepiscate Canyon, and it's a 60 to 65% grade, and that's really common in Tepiscate Canyon. So, what's the equal protection issue? We are in Ag 1, Ag 2 in Tepiscate Canyon, and that is, from what I saw today, cultivation, manufacturing, extensive use is planned to be permitted there. And I think the equal protection issue is because of similarities in the mountainous zones. Why isn't Tepiscate Canyon, why don't we receive the same treatment that these mountainous zones are? And I'm not recommending necessarily a change in zoning, but simply a prohibition of of commercial cannabis cultivation in Tepiscate Canyon. We'll work with you in the definition of what Tepiscate Canyon is. Thank you very much.
Our next speaker is Hunter Jameson, to be followed by Daryl Scheck.
Thank you very much for this opportunity to address the supervisors. My name is Hunter Jameson, and I'm a resident of Santa Maria. First, it is a good idea to prohibit growing marijuana plants outdoors in residential neighborhoods. I think that's an excellent idea and makes a good common sense. Second, the best approach to commercial marijuana businesses, in my opinion, would be to bar them. However, if the county allows commercial cultivation and related businesses, I would urge increasing the 600-foot buffer zone around sensitive sites such as schools to a minimum of 1,000 feet or possibly more. Third, it is now well established that the marijuana use poses heightened risks of addiction and harm for young people. I strongly urge you to protect our community and especially our young people by not permitting or licensing storefronts, micro-businesses, or pot clubs that would sell marijuana on site to customers. Although storefronts cannot legally sell to minors, storefronts, their presence, their advertising, make marijuana use more acceptable to young people and provide another source for pass-through supply. If there is a need for retail sales of medical marijuana, consider licensing retailers that will not sell by storefronts, but by delivery only. Delivery by their own carefully screened employees who would need to follow strict safety regulations and precautions in making deliveries. Thank you.
Our next speaker is Daryl Scheck, to be followed by Renee O'Neill.
Thank you, Chair Hartman and Supervisors. I want to thank the ad hoc committee of Supervisor Lavanino and Supervisor Williams for their work on this important issue, and I'd like to commend the committee's staff work as well. I'd like to request that this board does not over-constrain or overburden an economic activity which could be a significant benefit to the tax revenue of the county. The status quo with cannabis was not working, and this board has a golden opportunity to rewrite the rule book and do it in a way that protects the public while sustaining and enhancing healthy economic activity. This county needs more economic activity. Supervisor Adam, in a July meeting on this topic, stated, "It's just a reality. We've embarked on a societal experiment." I actually agree with Supervisor Adam that it is just a reality. The reality also is that there's a risk of driving this industry back underground and pouring more money down a rat hole on more law enforcement with no corresponding tax revenue to offset it. I also worry that in an unregulated underground Wild West type industry, public health could be compromised for consumers with no way to ascertain what's in a product. I urge caution on limitations with regards to zoning. You may want to continue to ask this question: is this industry being treated fairly compared to how the alcohol or agriculture or tobacco industries or vintners are treated? There's an old saying, somewhat appropriate since Goleta just concluded the Lemon Festival, and that was last weekend, and that when life hands you lemons, you make lemonade. I urge you to make lemonade out of the lemons that you've been provided. This industry is a new reality, and we hope you'll continue to make the best of the situation and hone the language so this can become a net positive economically and societally. And thank you for your time.
Our next speaker is Renee O'Neill, to be followed by Kyle Wolf.
Thank you, Supervisors, Madam Chair. I appreciate all the work you're doing and our entire committees are doing on this. My focus today is on community safety. For me, a safety acronym would include security, altruism, freedom, environment, treasured, and your constitutional right. We are a remote, isolated community being overrun by illegal cannabis growers, 21 farms to date. There is no regulation or enforcement taking place. Many of our residents are reluctant to come to the meetings or have their voices heard, thus are representatives of our canyon. We are not opposed to medical cannabis. However, we are deeply opposed to the fact that our community is at great risk. Not only our environment, but our safety, our very lives is at risk every time we drive down that canyon road. I agree with the setbacks. The greater the better. I can tell you from my own personal experience, I have a farm that's half a mile up the road from me. A half a mile. I can smell that farm. So I don't know what the potential would be to reduce the risk, the smell factor or those things. I don't know if there is one or if they can monitor that. I would just appreciate it if you would take all the things our community has been bringing to your attention for all these years into consideration and strongly request that you prohibit cannabis in our community. Thank you.
Our next speaker is Kyle Wolf, to be followed by Robert Fedor. Oh, okay. Looks like Kyle is left. Robert Fedor, to be followed by Mr. Bjorklund.
Hi, I'm Bobby Fedor with Melrose Herbal Collective. I want to thank Madam Chair and the supervisors. I know the Doobie Brothers are touring and made some time for us. But the bottom line is, I kind of liked what Supervisor Hartman had said in terms of a general picture. And I have a legal collective in Los Angeles, and I grow here, and I sell some of my product in Los Angeles, and the demand is there. There's 135 legal collectives in Los Angeles. There's 2,000 stores. Okay, there's somebody that's within half a mile from me that's open 24 hours. They let people smoke there. They have a wheel of fortune. If you spend $50, you can gamble. I can't compete with that kind of stuff. The demand isn't going anywhere. There's 1,000 McDonald's in Los Angeles. There's 1,000 Starbucks. There's 2,000 marijuana stores. I mean, we are dog paddling. Nobody's getting rich, I promise you. So moved up here 3 years ago with my family to get into the hoop house business. I strongly believe the future is organic. A lot of people are not. When those stickers go on those containers, they're not going to be able to make the cut. I guarantee you, it's very, very difficult to grow organically. So we're enjoying our life up here. I was here at the January 19th, 2016 meeting where you guys said, hey, we're going to work it out. We're going to let you know. And then there was radio silence, okay? That in 3 or 4 months we were going to let you know about the registry and how things were going to work out, and none of that was ever brought up again. So I'm not a mind reader. I'm not clairvoyant. I'm trying to do my best to self-regulate, and I just really hope that we can find a way for the good operators to work it out, and that win, lose, or draw. I appreciate everything that everybody's done. In terms of the zoning and stuff, I feel like the scariest thing I heard was Ag 1. And, hopefully there's
that is your time.
Something that can be worked out.
Our next speaker is Mr. Bjorklund, to be followed by Liz Rogan.
Good afternoon, Chairman, members of the board. Thank you for allowing us to speak today at this important meeting. I'd like to touch on just a couple topics here. Initially, on the start of the meeting, we had the option of doing one of three options. The first one was to ban cannabis outright. The second one was to kind of follow the state guidelines. The third one was to kind of reinvent the wheel. I'm supporting the middle of the road, the second option, which is following along state guidelines as much as we can. The work's been done. The laws are tough. We've got to comply with them to get that license, and we're going to need to comply with the county's laws to get your license. So the closer you can keep them together to the states, it's the easier it's going to be for us to comply. We're going to be providing a valuable source of income. Please don't reduce it unnecessarily. As far as addressing the Tepiscay Owners Committee, I bought a property up there, a 100-acre property, 10 years ago. I've been growing cannabis the whole time. I've never heard or had any problems until recently when it's being licensed and commercialized. For some reasons or another, some persons up there don't like it. But I think the farmers that I know, we all want to be good neighbors. We all have our own water. We're not taking anybody's water. We're not using groundwater. We're using deep well waters. The fire issues are very serious, not only in Tepiscay, but along the brush country behind Santa Barbara, Goleta, Carpinteria, Montecito, everywhere. Santa Barbara County has a huge fire problem. It's not just Tepiscay.
Thank you. That is your time.
Our next speaker is Liz Rogan, to be followed by Jared Ficker.
Good afternoon, Board of Supervisors. Thank you again for your time today. I want to specifically thank Supervisor Wolf for representing my district. Thank you very much. I want to also thank you for your time today. Guys, I know this is something we've seen each other a few times at least. You spent a lot of time talking and thinking about this, so I really appreciate your time and listening openly to our concerns here. One thing I wanted to address first was the Tepiscay Canyon issue. I've heard again and again about the fires, the fire danger there, and I don't disagree with that at all. But I am a member of the Cannabis Business Council of Santa Barbara County, and I do know for a fact that one of our cultivators used bulldozers to flatten an area so fire trucks could get in. He also allowed the person to use his water tank and access to a creek there. So I do understand that there's water concerns there, but at the same time, you have to look and see who's being a good neighbor, and without that, that could have held them back further, I do believe. Another thing I'd like to address is the odor and allergies that keeps getting brought up a lot. First off, there was a lot of rain last year, so there's a lot of plants this year, also a lot of animals. Regardless, that's causing a lot more seasonal allergies. There's more pollen in the air. One thing to note is that cannabis does not have pollen, at least the stuff we're growing. Hemp, potentially, but pollen only comes from male plants, and we grow female plants. So what is this smell that we're smelling? We're smelling terpenes. It's actually small oil particles. They're essentially volatile molecules that evaporate easily and readily announce themselves to the nose. Therein lies the basis of aromatherapy, a popular alternative healing modality. Terpenes are ubiquitous throughout the natural world. They're produced by countless plant species. They're prevalent in fruits, vegetables, herbs, spices, and other botanicals. They're also a very common ingredient in the human diet and have been generally recognized as safe to consume by the U.S. Food and Drug Administration. The terpenes of marijuana have given the plant an enduring evolutionary advantage. Some of the essential oils are pungent enough to repel insects and animal grazers, often
And that is
prevent
your time.
fungus. Thank you.
Our next speaker is Jared Ficker, to be followed by Sophia Van Wingerden.
Oh, great. Thank you. Chair Hartman, members of the board, my name is Jared Ficker with California Strategies, representing a number of existing cannabis operators. First, I want to thank you for your attention to this issue and your staff for the extraordinary work on the presentation you've received today. Dennis and Dan, thank you specifically. I know you guys have done a lot of hard work on this. I think the presentation received today was spot on. With one exception, I do want to mention that the default setback requirement in SB 94 does provide the authority for local jurisdictions to adjust setbacks up and down, and more specifically to apply different setbacks for different license types. So hypothetically, a lab might have a very different setback from a retail location. And lots of local jurisdictions are increasing setbacks for retail and reducing setbacks for other license types. So you have full authority to look at that. That was one of the things reconciled in that statute. I also want to mention in local jurisdictions, ordinances are preferencing pre-existing infrastructure with cannabis licensing, and this does not lead to a proliferation of new development, which I know we're sensitive to in this county. Finally, I wanted to briefly contextualize the supply chain a little bit, and I'm going to cover this very quickly, and some subsequent speakers after me might talk about some of these licensing types. We're moving from a patient plant collective model to a regulated business model, and we've talked about the statutory framework. What I wanted to do is, this is the old collective model supply chain, where you had nurseries, cultivation, manufacturing going direct to dispensaries, delivery, and then to a medical patient. Under the new framework, it's vastly more complicated. And there are a whole slew of license types. And while we've talked about the license types, I think it's really important to contextualize how the supply chain works and start thinking about it. So I offer this graphic and some subsequent discussion that's going to occur here today to just give you a little bit about how these different license types interact. It's a challenge not only for you making new policy, but it's a challenge for the industry to actually move into a different supply chain. Thank you.
Thank you.
Our next speaker is Sophia Van Wingerden, to be followed by Mike Palmer.
Chair Hartman and supervisors, I'm a third-generation farmer and cultivator in the Carpinteria Valley. I'm a partner in the family business and working towards full ownership. Thank you for the opportunity to talk about the cultivation of cannabis. It is a crop that is currently housed under the roof of our greenhouse. A few years back, we cultivated Gerber daisies and anthurium. Before that, it was chrysanthemums. We still grow and sell cut and field flowers, and it is a part of the business we are eager and happy to keep alive. However, it is a part of the business that has greatly decreased due to the influx of cheaper imported flowers. Growing cannabis has allowed us to keep and maintain our property, a property that I am not interested in selling, and a foothold in the cut flower industry. It has also allowed us to increase employee pay, benefit packages, training programs, as well as charitable giving to the local community. Our existing greenhouses and the infrastructure lends itself perfectly to the cannabis crop, just as it did for our transition from mums to daisies. What I would like to stress is our dedication to the best industry practices and our community. For example, we have eliminated all harmful pesticides from our growing process and use solely predaceous insects. We capture and reuse all water used for propagation. It is a closed-loop system. We have blackout curtains to help grow our plants and to ensure the elimination of night light pollution for our neighbors. We are continually investing in enhancing the odor control technology available to us. We understand what a serious issue this is. As longtime residents of the Carpinteria Valley, we have raised and continue to raise happy, healthy families here. We have no desire to change or disrupt this tradition. I am hopeful for the opportunity to continue my family business and to keep our numerous employees on the payroll. Thank you.
Our next speaker is Mike Palmer, to be followed by Graham Farrar.
Madam Chair Hartman, supervisor, staff, we really appreciate everything you guys are doing and everything you're going to do. My name is Mike Palmer. I'm a farmer in Carpinteria and a board member of the Cannabis Business Council. Thank you for the opportunity to comment on non-volatile manufacturing, packaging, and branding today. Non-volatile manufacturing, according to the state, includes processing, preparing, storing, packaging, and labeling of cannabis. Manufacturing of cannabis is no different than preparing any other agricultural product for market and simply includes trimming and drying. One of the most fundamental shifts under the new regulatory framework is the requirement that all product is packaged in its final form before distribution. This is a huge change from the current status quo in which flower is delivered directly to dispensaries in large bags and the dispensary does the packaging. Now farmers will be responsible for this step and in the supply chain. We need the ability to package, label, and brand our product for market. In order to package our flower, we must secure both a state and a local manufacturing license. It is critical that we can secure a manufacturing license at our existing farms, because otherwise we have to transport a large amount of flower to a secondary location. We have pre-existing agricultural warehouse buildings on our properties, and that are turnkey and support the cannabis manufacturing. Now we just need the ability to permit them quickly. The new packaging requirements present an existing opportunity in Santa Barbara for Santa Barbara County growers to develop brands specific to this region. Just as Santa Barbara County is known for its wine, our county has the potential to be recognized for its sustainable and responsibly grown cannabis. Thanks, guys.
Our next speaker is Graham Farrar, to be followed by Aaron Weber.
Hi, thank you very much, Chair Hartman and board. Again, appreciate all your guys' efforts on this topic. I also wanted to compliment Mr. Bazanich and his team for what I thought was a very good presentation to staff. It shows a lot of development of the appreciation and the nuances of this industry, which I thought was very good. So I wanted to talk about volatile manufacturing. I think we're a bit hamstrung because of the lexicon and the vocabulary that the state gives us when they talk about manufacturing. I think people jump to smokestacks and things like that. What we're really talking about is an extraction process that has been part of agriculture for a long time. Volatile in particular, I think, has a bad image because underground labs are often operated unsafely and have resulted in, in damage and fire and explosions. But these processes in these systems are not something that was invented for cannabis. These are not things that they came up with for this. This is are systems that have been around in agriculture for decades, from companies that have been around for decades. When we talk, it's just a different flower, a different agricultural material that's in there. It's the same thing that they do with lavender. There's lavender extraction facilities in Carpinteria that use ethanol. We have licensed distilleries in the county whose entire product is ethanol. This is the same thing that is used in these systems. So propane is another solvent, the same as we have in heaters and barbecues. These are not systems that we need to be scared of. What we need to be scared of is driving it to the underground, where we don't have fire departments and we don't have licensing and we don't have trained operators that are running them. So, and again, staff did a great job of showing examples of these machines. These are not backyard operations. That's what makes them dangerous. Done in a lab, they're low footprint, low impact, additional revenue. They're part of the value chain. It's part of what's going to allow our farmers here in Santa Barbara to compete by integrating and vertically integrating these systems together. And when done appropriately, they're very safe and helpful. Thank you very much for your time.
Our next speaker is Aaron Weber, to be followed by Paul Kowalski.
Good afternoon, Chair Hartman, Supervisors. My name is Aaron Weber. Thank you for the opportunity to speak briefly about distribution and testing. Under the new regulatory framework, a distribution license is required to transport any product. Distributors will be responsible for quality assurance and quality control, including compliance with packaging and labeling requirements. Additionally, distributors are required to hold product in quarantine until they can receive confirmation from a third-party testing lab that the product has passed test and is safe for consumption. Although we traditionally associate distribution with large semi-trucks, due to the small nature of the product, only small Sprinter vans are truly needed to transport cannabis. Vans can easily be loaded and unloaded in existing agricultural buildings with minimal square footage is needed. Another significant change in the new regulations is the requirement that all product is third-party tested. Note there are currently no testing requirements. Individuals that own other license types in the supply chain cannot hold a third-party compliance testing lab license. We already do not have enough testing labs, and as we see adult use come online, this shortage of labs will only become more acute. Third-party compliance testing labs are not only critical to protecting public health and safety, but also provide high-tech jobs. Permitting an adequate number of local testing labs is critically important to allowing farmers to prepare their product for market and ensuring that testing results are quickly processed and returned to licensees. A very small space is needed to run a lab, and we encourage permitting of labs on ag zoning near existing farms. Thank you for the opportunity to speak with you about the supply chain.
Our next speaker is Paul Kowalski, to be followed by Steve Junak.
Good afternoon, Madam Chair, board members, and staff. My name is Paul Kowalski. I'm the chairman of the Cannabis Business Council of Santa Barbara. I would like to thank staff and the ad hoc committee for the hard work that you've done and the things that you've accomplished in the past 6 months. I know it hasn't been easy. I spoke before the board in January of 2016, and I asked you to protect our patients' rights and our jobs. And I appreciate that you have done that. I would like to recommend that you support all types of licensing that are put forth by the state, including the micro business. That is the one that's actually in closest alignment with the current medical marijuana business model. I understand that the industry currently employs between 140 and 200,000 people, and that there will be a lot of growth in the industry in the near future. I wanted to talk about the people and some of the things that have been occurring in the state, a little bigger picture, and I'm going to reference a New York Times article in which they say that Hezekiah Allen, the executive director of the California Growers Association, a marijuana advocacy group, says that based on data from the various state and county agencies, they estimate 11% of the growers, about 3,500 of the 32,000 farmers in the Emerald Triangle, which covers Mendocino, Humboldt, and Trinity counties, have applied for permits. Many have been deterred by voluminous paperwork to obtain the permit, the fees, and the taxes. I simply want to again encourage you to make licensing something that you do to encourage compliance and to dissuade the black market. Thank you.
Our next speaker is Steve Junak, to be followed by John DeFriel.
Good afternoon, Madam Chair and members of the board. Thank you so much for allowing me to speak today and for all of your hard work on this really complicated issue. I'm a resident of Sabata Canyon, which you've heard about already, and several of my neighbors and I are very concerned about the recent proliferation of commercial cannabis growing sites in our rural residential neighborhood. We're hoping that you will not treat, as you've mentioned, all agriculturally zoned properties equally as this process moves forward, and we would urge you, please do not allow growers on Ag 1 parcels. We live in a community with parcels ranging from about 20 to 22 acres in size and share a common access road with our neighbors. Land that was vacant just 2 months ago is being illegally developed right next to that road. Several commercial cannabis growing operations have sprung up during the last couple of months without any apparent oversight by county officials. These operations have caused exponential increases in traffic from automobiles and large delivery trucks on this shared access road, increased water use, noise from people, generators, tractors, bulldozers, and other equipment. There have been extensive land clearing events and mature oak trees have been removed. Hoop houses and fencing are being installed only about 10 feet from property boundaries. If commercial cannabis operations were only permitted on parcels 50 to 100 acres in size or larger, suitable setbacks could be required to protect neighbors from many of the impacts that I've already mentioned, as well as objectionable odors and heightened security risks associated with cannabis production. Many of the concerns that have already been expressed by residents in Tepiscay and Carpinteria could be mitigated or eliminated by requiring larger buffer zones between neighboring human populations and commercial production. Limiting cannabis production to parcels 100 acres or larger in size would allow for setbacks needed to be respectful of neighbors. Thank you.
Our next speaker is John DeFriel, to be followed by Alberto Arroyo, who is our final speaker.
All right, good afternoon, Chair Hartman, Board of Supervisors,
and county staff. I'd like to also thank everyone on the ad hoc committee for their hard work. It's been a very inspiring process being part of this political process and watching the county solicit both public and industry feedback and to absorb that knowledge and to produce work that reflects where Santa Barbara County is today. As a businessman, the economics of all of these decisions are what drive me and my thought process on things. So my main urge today is to support the work done by staff, maintain a broad outlook. We still have to have the EIR back. We still haven't had an economic analysis back. Any additional further regulations you may consider putting in today, I would ask you to also consider what are the economic impacts of those things. If you do under 40-acre parcels, I know that my colleagues in Carpinteria employ 300 or 400 people just that I know about, and I don't even know every single operator in Carpinteria. So if you ban Carpinteria, you're talking about immediately hundreds and hundreds of jobs lost in Santa Barbara County. So what are the economic impacts involved there, as well as with setbacks? And I'm not necessarily advocating for the 6 plants in residential in backyards, but I do just want to point you to some specific language in Prop 64. If you ban outdoor personal production and or ban retail sales, as far as I'm aware, you are no longer eligible for state tax revenues. You will only get the county revenues. So you may want to consider carefully how you word that to get what you want, which I understand what it is you want. Just wanted to bring that to your awareness. So thank you very much. I look forward to working with you.
Okay, and thank you, everyone.
We have
we have
one
more.
final speaker,
Sorry.
Alberto Arroyo, who's our
Jumping the
final
gun here.
speaker.
Good afternoon. Thank you, Chair. Thank you, Board of Directors, for giving me the opportunity to speak on this hot topic. I'm currently greenhouse operations manager to a cannabis operation. And the reason why I'm here is to express my support on the cannabis license permitted to grow cannabis. And the reason is, here is the reason why. My family has worked in the agriculture greenhouse operations for many years. My father retired from working on the flower industry. My wife still works in the flower industry, but it's not easy. It's getting very complicated. I have 18 years of experience in flower growing. And when the project for growing cannabis was presented to me, I didn't have to think too much about it. And the reason is, here is the reason why. Again, the flower business is very complicated. I needed to have a job to support my college kids, and when the project was presented to me, it was very comprehensive, very responsible techniques of growing, and it'll keep me a job that will keep that will pay my bills, and that's why I am in support of cannabis growing, because it will not only keep myself with a job, it will keep many of my flower employees with a job. Thank you so much.
Thank you. So with that, we close the public hearing portion of today's session on cannabis. And what I'd like to do is, Mr. Bozanich, have you describe what we're going to do next, and then take a 5-10 minute break so that we can think about that, stretch a little, clear our minds, and come back.
Chair Hartman, members of the board, you may have noticed me busily typing things into some spreadsheets that might remind you, unfortunately, or fortunately, depending on your perspective, of the attachment E process we do at the budget hearings, as a way of kind of examining the opportunities for consensus around some of your suggestions that you've each raised here as possible licensing or permitting conceptual options that you would like to put before staff as we continue in this process. So what I would propose we do is either by a process of what you want to include or conversely what you might want to exclude to give myself and the team here some feedback, and I will do my absolute best to keep track of your comments on that chart as a way of just kind of assessing where we might have some common ground and consensus and where perhaps we don't. And again, this is very different than the attachment E process in one key factor. You're not adopting anything today. This is purely conceptual direction. This is not going to get entered into anything as formal as our county budget that we do in June. So I hope that is a simple enough explanation for the board and for the public to understand. Two pieces of paper that I think might be, actually three pieces of paper that might be valuable for you as you begin to think about that. One is this page 13 of the board letter, which had the 8.5 by 14 version of the different zoning areas and license types. One of the things I will point out on this sheet is the license types for agriculture. You know, I have that rather expanded list based on whether they're mixed light, outdoors, or indoors. That all gets shrunk down into one line. And so as you're describing perhaps things you would like to see around licensing or permitting, if there's a distinction between indoor, outdoor, or mixed light, please, let me know that as best as possible. So that's one piece of paper that I think will be critical. The other two go back to slide 7 and slide 9 in the PowerPoint presentation, because those have a little bit of the narrative description about what the different license types are that are not found in the one column on the slide. So I hope that helps as some basis for our discussion following the break.
Supervisor Williams, did you have a question? Okay, so 10 minutes. Everyone take their seats, please. We're reconvening the September 19th, 2017. We're reconvening the September 19th, 2017 Santa Barbara County Board of Supervisors hearing on cannabis. After a short break, we're coming back, and Mr. Bozanich is going to lay out a model for us for giving him some conceptual direction. And I asked if we might first discuss cultivation and then weigh in. And I think it would be helpful to me. I'm not sure exactly where I stand, so we might tentatively say like a vote, but if there are issues to be discussed, then we could listen, deliberate, hear from each other. Yes?
Just a real quick question. Mr. Bozanich, that chart on page 13, the one that you mentioned, is there any way that we can work from that instead of this? Because the chart that you put together seems like that's what staff has recommended.
The advantage is that we're looking at licenses by zone type.
Yeah.
So the larger one allows us, that's where I think some discussion, maybe we could just discuss it generally, and then you could ask each of us how we want to weigh in.
Kind of fill it in that way.
With that?
Chair Hartman, Supervisor Wolf, that's a fine suggestion. Maybe I'll ask Mr. Lehman here to work on getting the board letter up for me from the packet.
Oh, that's a good idea. And then you just pull page 13.
Yeah. So I think rather than reinventing the wheel, so I think we could do that. And I guess one of the pieces that I would also suggest, and we'll start with cultivation if you want to think about that, and recall if there is something you want to do differently based on size or by the kind of the environment in which the cannabis is growing in, meaning indoor, outdoor, mixed light. Those are really the variables. And I guess the piece I would say is if there's something you really hate, then we should make sure we get a note of that. And if there's something that you can live with, We're going to continue to keep all options on the table for this conceptual discussion, but it will be helpful as we kind of move further down the planning and development of any kind of ordinance languages around licenses and permits to know where the general direction of the board is conceptually at this point.
And I had just a quick question on the Type 5 large licenses. Can we just not discuss that today, or is there some urgency given that the state isn't going to act yet?
Chair Hartman, I would say we can definitely wait on that. There's no urgency from the state standpoint. They're put it out till January of 2023. I'm sure we will learn a lot, and I'm sure all of this will change 47 times between now and January of 2023. So I think to spend a lot of time on that decision process at this point would not be valuable.
And I just had a question. Could you describe what a nursery license is?
Sure.
I don't understand that very well.
So, Chair Hartman, a nursery license is really, as it implies, the propagation of the cannabis plants in a nursery, think plant nursery setting. So these are the baby plants. Most often in current cultivation practices, they're clones off of another plant. They literally take the little parts of the leaves that grow at the joint where the other leaves meet the stem, and they pull those off, and they use rooting compound to put them in there, just as many other plants today are ostensibly clones of their parent plants.
And is it indoor, outdoor, and does it relate to size like the other three indoor, outdoor, mixed light?
Chair Hartman, it is separate from the size requirements. That does not, and it could be, depending on where the plants are then intended to be grown later on, you would tend to perhaps start them and have a nursery for an outdoor variety and outdoor plants in an outdoor nursery setting, but it is really separate and distinct from a size requirement or a growing environment requirement.
Supervisor Williams and then Wolf.
Well, one question before are we going to then begin it? Are you pulling that up? The dovetailing on Supervisor Hartman's question on the nurseries, do they have the same kind of odor impacts because they are immature and non-flowering plants?
Chair Hartman, Supervisor Williams, I have no idea. I would think they're smaller. Per square foot, the density of the plants would be far less because they are literally the small initial growings of the plants and initial rootstock of the plants. And the density would not nearly be the same as you would see in full-grown plants. So as I've walked into a greenhouse or even an outdoor facility, full-grown adult mature plants, even adolescent plants are anywhere from 2 to 5 feet, 6 feet tall in those settings, and they're very dense, whereas these small immature plants would be much smaller, which I would think would have far less odors. And but if you want to consult with somebody from the industry, perhaps we could do that too.
Supervisor Wolf?
Madam Chair, I was just going to get started on the yays and nays, but I don't know if we're ready.
That was my intention too.
Okay, let's make sure that we're ready to record or to discuss.
Can I bring up a couple things that aren't on this chart? I'm not sure if we talked about capping, like, for instance, the number of dispensaries, if we go there, or cultivation sites. I know St. Louis has capped cultivation. Have we given any thought to that?
Supervisor Wolf, through the chair. So in both staff discussions as well as in discussions between staff and the subcommittee throughout this process, the question of caps for various license types has been brought up and been discussed. It was actually raised as one of the issues. I believe Chair Hartman raised it as one of her considerations as she was thinking about this conceptual direction today. So a couple things about caps. One, they are difficult to administer in the sense that you got to have some mechanism for deciding who is within the cap, and then who, by then definition, who's outside the cap. So is there some kind of a selection process, or is it everybody, whoever's first in the door gets their license under that capped regime? Or do you have some kind of a selection process? So for example, the City of Oakland, for their dispensaries in the City of Oakland, they had an RFP process where people made proposals to get one of the 5 dispensaries in the City of Oakland. So, and then other organizations have done a lottery where you kind of spin the dial or spin the wheel. And then other places have turned over the decision about who gets a cap under a license under a cap, or based on third-party criteria, third-party evaluator coming in and making that decision. So as staff has looked at it, we've kind of identified those as possible methods, but recognize that it adds another fairly intensive process, to this already new and complex process. So I hope that helps in the discussion and thought about that. But many agencies have looked at caps.
So we have the page 13 ready to go, and I just want to make sure there's something we don't have to discuss and relates to caps, and that's concentration. We'll come back to some of these issues, right? Today our job is to get through the license types and give you some feedback about what else we'd like to know about next time. Supervisor Wolf?
Okay, thank you, Madam Chair. So I guess my comments are based upon the information we received, and one of the most helpful things that we received for this discussion is one of the attachments, which is all of the different zoning types. I do appreciate the time and effort all of you have put into this, but when I look at making these decisions, and particularly this one, where we don't have necessarily a state mandate like we did when we were talking about, was it AUDs or ADUs? When we that was pretty strict restrictions that we had to abide by. Here we're given discretion, and when we're given discretion, for me, in looking at that, I look at my community plan, I look at input from residents, not just residents in the 2nd District, but particularly on this issue, we've heard from so many that their lives and their way of life have been impacted. I also look at public safety and public health, and so those things help me with my decision making. So I don't know, I'm going to just go through some of these things. I guess at the very bottom, this is probably the easier one for me, is mixed use. And I hope I articulated why I didn't believe that we should include mixed use in this regime at all. Mainly because it incorporates residential. And we have, by design, eliminated all residential. So it makes perfect sense, in my opinion, to eliminate mixed use. Now, moving up to the top, I am also very much opposed to any of the license types in Ag 1. Again, as I said in one of my statements about the Eastern Goleta Valley Community Plan, was very specific in maintaining our small ag parcels and using them as family farms for the community. And I don't believe that this was ever contemplated as part of that plan.
May I ask a question, Supervisor Wolf? On Ag 1 outdoor, would you consider warehouses or greenhouses on Ag 1, or absolutely not on Ag 1 at all?
Nothing on Ag 1. On Ag 2, those larger parcels that Supervisor Adam talked about, I'm intrigued about that. I think it was Ag 240 that you mentioned, is that right? So that is something that minimum that I would consider, since this is just giving you some input. But I am concerned about the distance from residential property to, or an urban line to these ag parcels. So some distance between, and I don't know what that would be. Now going down to manufacturing, the non-volatile extraction, you have.
Could we do cultivation first and
Sure.
then come back?
That sounds good.
That way we could talk a little bit if there's more, and then we
Okay.
have that and go to the next.
So I guess I've done mixed use and did I do cultivation? Okay.
Okay. Supervisor Lavanino.
I think Supervisor Williams had his light on.
Oh,
That's okay.
okay.
Yeah, okay, all right. As far as cultivation goes, the only, what I would like to see is, and this is only because we've studied this a little bit more, and I think you have to look at the maps and see what you're allowing and what you're not allowing. But I think if you went to a 7-acre min, then what you do is you actually do eliminate a lot of your Ag 1.5s that are a lot of your problems that you run into. But, you know, I have a little bit of hard time doing this before we get with the EIR, but just to give guidance, I mean, of what we've looked at generally and what I've studied the maps to see, the areas, if you go a 7-acre and above, it really does eliminate a lot of the interaction between some of the smaller ag zones that are close to residential, but it also allows you to, you know, on a 7-acre parcel or 8-acre parcel, we have to realize, we also have to remember that the largest grow you're allowed to do with a license right now is 1 acre. So although there could be multiples on that site with setbacks and whatnot, that's kind of where I'm going. I think if you really go down and you say it can't be on anything smaller than 40 acres, you're basically wiping out the South Coast, and I think that's in effect that's a ban of just about anything south of the tunnel. So I think we'd have to really look at the map more and put circles around what what's available and what isn't available, because by the time we've done this exercise, so I've been through this, I know, but when you start putting down your buffers around your sensitive receptors and then you start blacking out where you can't cultivate, you pretty much end up with not a whole heck of a lot left down south. So that's just my 2 cents.
Just to clarify, if I could, Supervisor Chair. So on the idea of an Ag 1, or cultivation on Ag 1, 7 acres or more, is that indoor, outdoor, and mixed light?
I would allow all.
Okay.
Yeah.
Well, I guess I'll try to use the same threshold. I do think some acreage limitation on some of the types would be one way to get around some of the neighborhood issues. I don't know for sure what the right threshold and size is, but for the time being, I'll go with Steve's one. In 7 or less on Ag 1, I would say that it wouldn't be a good idea to do an outdoor or an indoor grow. I think we should at least look at the mixed light permit types and the nursery permit types in the smaller Ag 1 parcels. I'm not saying absolutely got to happen, but at least look at that. And then I would be supportive of mixed light in the Ag 1 over 7 acres, and Ag 2. The outdoor grows, I would only support in Ag 1 over 7 acres if there's some kind of odor control requirement. Yeah, and I mean an odor control. No, I mean an odor control requirement for proximity, meaning outdoor grows can't really do odor control, but so essentially a certain proximity from neighborhoods, there just shouldn't be any type that can't do odor control, and so that's to me a big issue for Carpinteria, and one that I'll definitely dig hard on. Odor control needs to be mandatory, and I'll further say this is why we need to have some kind of a voluntary consult process in the coastal zone, so we don't have to wait until the coastal commission approves the ordinance for residents to get any odor control, right? They don't want to wait, another 15 months. They want to get it as soon as possible. And so I really want to implore growers to purchase odor control as soon as possible. I know many that are doing it, but that we should have some kind of voluntary consult process with P&D so that we can incentivize odor control devices being adopted before the ordinance comes into effect in the coastal zone. And that's a really big issue to me. So so I think I've gone through that essentially mixed light. I can see it in all the zones that you've studied it. The outdoor is most appropriate for Ag 2 or large Ag 1 parcels far away from residences. And that indoor operations, I know that seems to some people just sort of like a panacea because it's out of sight, out of mind. Well, they just can have a lot of problems. I mean, unless we are going to have some strict standards in permit compliance. So I could see them in all the zones that you've articulated where if we mandate, a state licensed apprenticed electrician to do their electrical and that they do solar, because otherwise they're going to make everybody pay higher energy rates. So I'm not exactly a fan of indoor grows.
Supervisor Adam.
Are you done, Supervisor?
Yeah, those are the types. I don't know if I went over the nursery, but the nursery, I see that as being pretty viable over all the zones that you've put it as a study.
Okay, so obviously I'm still at no residential production outdoors, no production in mixed use areas. I'm still stuck on no production in Ag 1 because Mr. Gazzoni, you might want to help me with this. You can't do parts of Ag 1 and not other parts in the county, right?
Mr. Razor, that goes back to the uniformity piece that I was talking about before, that if we're going to have Ag 1 in one part of the county, we would generally want to treat it the same as throughout the rest of the county. And then
Might I add, because we can distinguish between warehouses, indoor, greenhouses, and outdoor growing. So, right? In other words, for example, in Ag 1, we could say we would allow indoor or greenhouses, but not outdoor growing.
yes, because that would be, again, that would be focusing on a use that would be consistent for that type of zone wherever it was.
Okay, my problem.
You could also set a threshold of acreage
Yeah.
within that.
Yeah, my problem with that idea is I don't think that the odor control is really as, from what I hear, it's not as effective as it sounds. And so, what I would like to see.
You should check it out.
Okay. Well, what I would like to see is to make absolutely sure, because odor is seems like the biggest problem, what I would like to do is see if they work and do a couple conditional use permits and things that where somebody is representing to us that they're going to solve this problem, and then we can make sure that they do. Otherwise, you yank the conditional use permit. But by right, we've got these a whole bunch of parcels and a lot of acreage that you can capture if you go out to 40 acres. And 7 acres is 552 feet square, and 40 acres is 1,300 feet square. So, you know, you're a lot further away. You know, if you wanted a 1,000-foot buffer, you know, on a 40-acre parcel, you're talking about another 40 acres, and that's mostly what's next to a 40-acre parcel is another 40-acre parcel or bigger. And so I'm trying to get it out of the urban interface, and maybe there's 1 or 2 houses out there. And like I was talking about earlier, if there was a buffer between the old house and the parcel next door that wants to go into that production, you know, that's as good as we can get. Because if we're going to allow it, you know, what I'm trying to do is maximize the number of parcels that can be productive and minimize the number of people that can be inconvenienced. And so I think the way to really tackle that is to send it out into the larger parcels, and that way, you know, hopefully there's not another really tiny parcel. And, you know, we may be screwing somebody even at that, but, you know, sorry, but you can't solve everybody's problem all the time. So, you know, I mean, I think I'm stuck on AG 240 for production.
Supervisor Lavanino?
Thank you, Madam Chair. I did have a correction. I don't know if I misspoke or not, but so I just wanted to say that I did support also mixed light on Ag 1, so I don't know if I had said. So anyway, just so you know.
Got it.
And if I could, I'm talking about any kind of production at all, mixed light, indoors.
So for you, Carpinteria would just be wiped out.
Yeah, you know, it just doesn't work. It's all interspersed with people, and so that's the problem I have. Now, if you want to try a couple CUPs down there, and you know, if somebody can really prove that there's no long-term issues.
Well, the issue is you would have a license issued every year, a business license, and if you don't fix the problem.
Okay, just a second.
What's going on? If you don't fix the problem, then you don't get your license the next year. You're not married. It's not like a land use permit where you're married to it forever.
I don't know. I think you get investment back to expectations at some point, right, Mr. Gazzoni?
Chair Hartman and Supervisors, we've talked before about what licenses generally do, which tend to be more ministerial, and what zoning does, which is establish what is by right or what is going to come with a CUP. So typically, if we're going to have wholesale inclusions or exclusions, we'd be doing that through zoning.
Yeah, so, but it's a ministerial thing until it's not anymore. I mean, you know, if you allow somebody to go put something up and it's not in the form of a CUP, where it's clearly something that you can yank back if it doesn't work out, then, you know, this is what scares me, is there's too many variables and there's too many people that are going to get affected by this, whereas out there in the hinterlands, you know, it's just, it doesn't have the number of people that can be affected.
Okay, let's see. For Ag 2, I would be supportive of indoor, outdoor, and mixed, but I'm eager to learn more about, you know, buffers and how we avoid nuisance. For Ag 1, I would be only for indoor and mixed. And to get to Supervisor Williams' point, I think it is important that there be permitted buildings, that they comply with the building code. But I think, as some of our public testimony suggested, a preference for those with existing infrastructure that can be adapted. And as far as nurseries, I need to learn a little more about them and what goes with them. Okay, Supervisor Wolf?
Thank you, Madam Chair. So are you saying then, is there no cap on Ag 1? Because I know you were talking about your district. I have Ag 1 in my district. So are you saying that indoor, would that be hoop houses, or
No,
what are you
they're
envisioning?
warehouses and greenhouses, and I'm very interested in a cap, but I think that's for another day.
Okay.
Janet, just so that you know, I've been talking about a cap at every public hearing of the ad hoc committee because really the question is important to Carpinteria. There's got to be some limits.
So I guess to staff, because you were saying that caps are difficult to, but I think if we go down this road, which would be hugely disappointing, but if we did, then it's really important then to have these caps. A large part of the Ag 1 in my district is in the coastal zone, but there's certainly a lot that's next to residential neighborhoods. I just want to restate my opposition to Ag 1, and I think Supervisor Adam was on the right track there. But definitely, if you go there, it's got to be capped.
So we're turning now to manufacturing license types.
And members of the board, I would just suggest that we can include testing labs in this part of the process, kind of take that whole middle section of the chart in front of you on from page 13. So non-volatile extraction, volatile extraction, and the testing labs.
Supervisor Adam.
Well, I think all of this stuff should occur on all of those same parcels out there in the greater than 40 Ag 2. And, then you've got the efficiencies of the whole thing being occurring at the same time. And not only that, but, if you do have a problem, it's out there and it's not in amongst a whole bunch of houses. And then regarding the testing labs, I think that's just fine anywhere in a commercial zoning where you would have, where it would be appropriate to have any other lab.
Supervisor Wolf?
Thank you, Madam Chair. I think in concept, I agree with Mr. Adam, just a couple of changes in my thoughts. The non-volatile extraction that is listed for C1 and C2, in the attachment that we received from you that discussed different zones, C1 is really specific in its description that it's be compatible with neighboring residential uses to protect residential uses from negative impacts, including noise, odor, lighting, traffic, or degradations of visual aesthetic values. So, and that is C1. C2 is also very much like that. It talks about the allocating of services for residents of the surrounding area. So, in my opinion, I would not allow non-volatile extraction in C1 or C2. I think C3 is okay. As I read C3, it mentions that it's really appropriate for wholesale and heavy commercial uses. So I think that would be acceptable. So I think eliminate C1, eliminate C2, C3 would be acceptable, CS is acceptable. I'm going to drop down to the testing lab for PI.
Chair and Supervisor Wolf, just to clarify, then were you still back to supporting the non-volatile or volatile on the Ag 240 properties?
Oh,
that
no.
No?
For yes.
Okay.
If it was.
Can I ask you a question? So you're wanting to do more in terms of extraction, both volatile and non-volatile. You want to do all the C zonings in addition to Ag 2?
No, I would eliminate C1 and C2. But and I would love to, yes, I would love to eliminate all commercial zones and the shopping center and just do what Supervisor Adam said. However, I'm theoretically okay with C3.
And that's because?
Because of the zoning description that doesn't, it says that it's appropriate for wholesale and heavy commercial uses that are not suited for commercial zone and accommodate lighter commercial uses. So, and that's the only one. The other two definitely talk about residential, so that's why I'm okay with C3. PI, I'm going to say again, makes no sense because that's institutional, educational, and the other three, MRP, M1, and M2, I would also be okay with.
Let's see.
And can I just say one other thing about these? No, that's okay. This is, never mind. I'm fine. Thank you.
So Supervisor Williams, you haven't weighed in on this yet.
I am supportive of the non-volatile extraction type 6 licenses on all those zones. I mean, I guess I'd be more interested in your point if there was more than like 3 parcels of C3 in the entire county. There's like, I mean, I'm just looking at the maps. There's like 3. There's like a handful.
Since you brought that up, in my district, the C1, C2, C3, and shopping center are combined in my map, and they're definitely shown in the map. So you may have had more specific information on where C3 is.
You can see it in the buffer maps. It calls out C3 separately than C1 and C2. So if you want to differentiate that and see in the maps that you can, but I just wanted to get through. The volatile, it is, I think, scary sounding, but not really as scary as it is sounding. But I do want to bring a twist of an issue, which is what happens. And our ad hoc was asked by the city of Carpinteria, well, if we permitted volatile extraction, we don't want you to permit it right next to us, right? And I think that'd be fine as a good neighbor. So I would permit it in all zones, except maybe have an exclusion zone around a city if one of our cities permits it. Because frankly, they have more industrial land than we do in some cases, and so that'd be my preference. And I thought I'd bring up that issue because it hasn't come up yet. So
can I just ask a question? Sure. So are you adding commercial then for volatile extraction where it doesn't exist up there?
No, I am not.
So
he means in the ones that are X'd already.
Yeah, in the ones that are X'd already, I would be okay with them existing. And again, I would tend to think that the manufacturing zone and some of the larger ag parcels is where it would be most appropriate. But yes, but I just added this little twist that I do think that when an adjoining jurisdiction wants to permit in their industrial zone, they have more industrial land than we do.
Correct.
Maybe makes more sense.
Supervisor Lavanito.
I missed something, but I think we're getting punchy. I'm good with type 6, 7, and 8 at the ones that are already listed. And, I think when it gets down to it, businesses will make a decision, whether if it's better for them to be inside the city or inside the county based on how it's permitted and regulated and what it costs them, so.
Supervisor Adam, you had something to add?
Yeah, well, I just want to clarify my position here. I think I started out with the AG 240 for extractions, and I can do AG 240, C3, M1, and M2, but not AG 1s. because, you know, there's so many neighborhoods that are rural neighborhoods that are composed of the AG1s, and I realize that this industry has sort of grown up in the AG1s because they're small parcels and people got a house with a small parcel and all that. But now we're going from something that was sort of a boutique-y thing into real production. And I think it's inappropriate that those neighborhoods get invaded with this kind of stuff.
Madam Chair, you know, and this has kind of opened a thought to me through this whole process is Ag 1 Ag or isn't it? I mean, when people come here and they want it to be Ag, everybody argues that it's Ag. And then when they don't want it to be Ag, they're like, well, we're just Ag 1 and we're a neighborhood. Hey, you're one or the other. You know, so, yeah. I mean, after a while, people argue on both sides of it, and it gets frustrating.
Well, I'm on the Triple T side, you know. That's the side that we didn't let somebody do something with a winery. And, based on the fact...
Let's keep on this topic here, if I could.
I'm just explaining myself to the comment.
But if I might register, and I don't have, first of all, I'd like testing labs wherever they're appropriate. I want to encourage that. I think that's a good opportunity for well-paying jobs. In terms of where to allow volatile and non-volatile, I'm persuaded by people I talk to that volatile isn't, that we're already doing it with lavender, that it isn't something that is as bad as it sounds. I, again, am interested in vertical integration. I'm interested in trying to help people who are here capture the value. So my inclination is to go with extraction, volatile and non-volatile, on Ag 1 where it's indoors or mixed light, like I said before. That's where I would support it. And also on Ag 2. And I'm less certain, and I need a better argument about why we would want to take it off to other commercial area if you could do it right on site. So I'm open to learning more about that, but that's where I am right now. So I think we have that, and we're ready to go to the next category.
That's correct, Chair. So the commercial areas, retailer, distributor, and micro business.
Could you say more about what a micro business is?
So, Chair Hartman, it's a good question. So it's imagined to be kind of the equivalent of a small enterprise, kind of maybe led by an individual or a small team of folks that has the benefit of a small cultivation site, a small manufacturing, non-volatile capacity at that, which could include oil creation and/or edibles with a suitable commercial kitchen that's for cannabis only, as well as the distribution retail piece. It would not, they would still have to outsource their testing to the third-party testing agency that you've now emphasized because of the good-paying jobs. And so that it's really meant to be a much smaller, fully integrated enterprise.
Okay, who wants to go first? Supervisor Williams?
Well, I'll say that I'll preface my comments by just saying that I really believe that for safety reasons, we should be having storefront retail and not have delivery services. Currently, there are a lot of delivery services that are operating. I've asked a lot of people in the industry and a lot of law enforcement folks about it, and what I get time and time again is these delivery services are a lot more vulnerable to being robbed and a lot more difficult to regulate than a storefront dispensary. A storefront dispensary you can require to have cameras. You can require them to have security guards. You can possibly even require them that their some of their records is open to law enforcement to use as part of a discretionary permit requirement. We can't effectively do that on delivery services, right? All they are is an app, right? Someone just requests and they come in and they go into your neighborhood and deliver it to the door next door to you. And I think if people knew that, you know, the kind of choice was between having a few storefronts in the county or having basically the house next door to you being a de facto storefront on any given occasion, then they'd see that it would be a lot safer if we did that. So I would bifurcate my opinion on this by saying that we should permit the retailer license in those zones that have been indicated, but number one, restrict that to storefront only, not to delivery services, and to have a very a restrictive cap. I do not think there's a reason for a large number of these. That combined with the buffers, I don't think there would be very many of these cited. If you look at the maps, there's just not all that much commercial stuff outside of the buffers. And if we limit it with a cap, then we could have enough so that people can get their medicines, but not so much that we have a large proliferation as we've seen in Colorado. The distribution license I support in those zones. The distribution, really, this is about part of the supply chain that I don't think will have as much impacts, but yet it would have a lot more benefits for us. So just impacts versus benefits. To me, the benefits are heavy on that. And the micro business, for the reasons why I just articulated, I would not support it in the Ag 2 because it has delivery, right? There's a delivery component to the micro business. I would, and therefore I would not support it in the Ag 2, but would support it in the other zones.
Supervisor Wolf.
Thank you, Madam Chair. For the reasons that I explained about the manufacturing and commercial zones, it's the same that I feel about commercial sales, especially in C1 and C2, and sorry, retail, yeah. And I guess I would, if we're not doing it in commercial neighborhood or neighborhood commercial, why would we do it in C1 and C2? Can staff answer that? What is the difference between those designations?
Yeah, Madam Chair, Supervisor Wolf, in general, without going into the details of them, you can kind of think of, how would you say, greater allowance of retail in the commercial zone. So the shopping center zones and the service commercial zones, those are really trying to tailor to certain types of markets, localized, or trying to provide certain types of retail, whereas limited commercial, it's allowing more general types of commercial, and then going up to the full C2, that's where you have a more robust retail commercial stores. But I mean, besides that, it's just a matter of scale and to whom you're marketing and what you're trying to address.
Well, so I'm thinking about what is the zoning for Turnpike? The Turnpike shopping center. Is it shopping centers?
I'm pretty sure it's, SC Homes. SC, I'm pretty sure. Yeah. Yeah, if you go to attachment to the Goleta Valley area map, you'll see it's. Yeah, we have them combined, so I'd actually have to look at more precise zoning maps to answer that.
I have it up right here.
I believe it's SC, but
It wouldn't matter because it's all covered by the 600-foot buffer from the high school.
Well, not according to the buffer map. There's still
The
part of
buffer
it.
maps are parcel to parcel, so it doesn't matter if not all of the parcel is in the buffer. If any of the parcel, it touches the buffer, it's all excluded.
Okay, that's fine, but that's not what the map shows. It shows right where the San Marcos Continuation High School, it shows part of it still being outside the buffer. So basically what you're saying then is all of the Turnpike Shopping Center is within the buffer and nothing will be allowed there. Is that what you're saying?
I'm saying that any parcel that touches the buffer it's not allowed anywhere on the parcel.
Parcel's out.
So just going to that Turnpike Shopping Center, is that what you're saying?
Yeah,
That
no one
there's
would get a
nothing-
permit on that shopping center.
Because it's within the buffer.
Or between sensitive population.
So I still do not believe that we should have retail in C1 and C2. And I just want to make a statement that, we have a law on the books right now that says that we don't have medical marijuana dispensaries. Is that right? And that's a total ban in all zones, right? So it makes it even more difficult for me that when we have a ban for medicinal dispensaries, to open it up to recreational dispensaries. So I just have a philosophical problem about that. And so, anyway, definitely not. C1 and C2, I just think are off limits, and especially, and also for micro businesses. That's it.
Supervisor Adam.
So Supervisor Wolf, you're okay with C3, CS, SC, and M1? Okay. Okay, I can live with that for retail, but I don't want any.
Can I just say one thing?
Sure.
With the provision that we have caps.
Right.
And I think, again, that's probably one of the most important aspects of this whole thing, so that we don't have a proliferation of dispensaries in the county. Maybe one in the North County, one in the South County. And if I can also just say one other thing, sorry, Mr. Adam.
Go ahead, yeah.
The city of Goleta, I think, has 2 or 3 dispensaries, and city of Santa Barbara, I think, maybe has 3. So, I really don't have a problem or worry about people being able to access. I do worry about having a glut and turning our communities into something that I don't think we want them to be.
Well, I would caution you to be careful with that, because there's another type of a business locally here that experienced a, what do they call that, a monopoly, because after they opened, then they shut the door, the city shut the door on further those type of businesses, and so then they end up with a monopoly. So I think that it's always good for the markets to have some choices, and I wouldn't like to see it capped at that small of a number, because then you're just ensuring that those businesses are going to be successful, and we are picking some winners and losers here to some degree, and I think we should be a little bit careful about trying to say the first guy through the door is going to be successful no matter what happens. So for me, I'm okay with those retail locations, and I would like to see a higher limit. If we're going to put a limit on it, I'd like to see 10 or 20 rather than 1 or 2. the thing that's important to me is that at those locations, there's no use on site. You know, you come in and buy your stuff and take it home and do whatever you do with it. Distribution is another thing. You know, I would be opposed to distribution from AG1 parcels. AG2 is fine. C3 is fine. MRP is fine. M1, M2, fine. And then the micro businesses, I'm just entirely opposed to the idea of it because I think these guys are the hobby guys. And maybe they do some things well and other things not so well. And, you know, I think those are the ones that are going to be the problems. You know, if you're going to have professionals out there doing this stuff, and I understand, you know, there are a number of people that are very professional in conducting this business. Not that I agree with it, but I recognize their professional expertise and their ability to execute without causing problems. I think those micro business ones are not those guys. Because they're trying to dip their toe in the water, maybe, or they can't afford to properly outfit themselves, and so that'll be something where I think there's going to be a lot of problems associated with those, and I'd rather not have those.
Can I just clarify? I don't think I said, Mr. Bozanich, for distribution, nothing on Ag 1. And also on the micro business, not on C1 and C2.
Supervisor Lavanino.
So you're good with them in the other areas?
Yes.
No, I know you're not.
Do you want me to read this for the fifth time?
No.
Because there is a rationale to.
It's funny because
you know what, there is a rationale.
When I'm not going to vote for something, I rarely get to direct as much as we're getting directed.
All you have to do is just look at the zoning definition, and it makes it really easy.
Okay. So, type 10, X is where they are. Type 11, X is where they are. And I think we need to. I even need to probably have micro business brought back to us, maybe just a short presentation because I don't understand it as well either. I think it's very important for the supply chain. You know, and I've gone back and forth with caps on retail. Nobody wants to see like a huge proliferation, but at the same time, then it feels super hypocritical that you're saying, yeah, I want to grow all this here and we're going to make money from the cultivation, but I don't want to sell it anywhere. You know, it just doesn't seem right. But I know, and the other thing is, you know, like I know the city of Santa Maria is banning sales, but I think San Luis Obispo will probably put one right across the bridge right there. And so they're going to get all the impact with none of the revenue, so then you don't have the money to fight the problem. So, you know, I mean, it's another source of revenue. Looking at this, though, the reality, and I was completely backwards on this at the beginning, I thought that the revenue would come from the retail. It really is probably going to generate more at the cultivation site, and the retail will probably be a fraction of what we get from the others. But I'm okay with what we have listed here.
Yes, Mr. Bozanich, did you want to say anything? Or well, the distribution is simply those vans taking it from where it's cultivated to the distribution center, to the lab, back
Right.
to the distribution center, back out.
That's correct,
Okay,
Chair.
and so I would have to have distribution where I allowed cultivation, right?
It would make more sense.
That's all right. So that's what I'd say. In terms of retail, I strongly agree with the others who said no consumption on site, no pot cafes. And I've heard it both ways, that it's better to deliver, but I've been persuaded, at least for the moment, by Supervisor Williams' storefronts. I'm thinking about how to regulate. We have to go from 0 to 100 very quickly, and that's one reason why I think caps are really important. And I think trying to have it not too dispersed is also important. So In terms of retail areas, I guess I would default to what Supervisor Wolf has suggested because she's generally has the narrowest parameters on this, so I would agree with her on that issue. And micro business, I don't know what it is really. I mean, again, it goes to the issue of regulating and how to do that most easily, and you get a lot of, we can change this over time, but let's start with what we can actually do and do well. So that's where I am on that.
And one
Supervisor Lavanina.
I don't think I talked about, thank you, Madam Chair, delivery. And I even though I'm okay with having a storefront, I think even if you look at any business right now, retail is taking it, storefronts are getting smoked by delivery. And so I don't think it's, what's that? Smoked. Yeah, I'm sorry about that. It's getting late. But I don't think it's either or, is it? I mean, to me, I think why wouldn't you be able to have both? Those that want to deliver from, if you, let's say you're on an Ag 2 property and you have that license and you also have the delivery license and you don't necessarily want a relationship with a dispensary, that's your business prerogative. If you do want to deliver to a dispensary, then that would be something else. So, I mean, for me, find them to be exclusive of each other, and I would support both and see which one ends up business-wise working.
Supervisor Williams?
I know we don't disagree on much on this. I just want to say that there is just, the reason is because it's too easy to rob them, and they don't report the crime when they do. I'm talking about delivery services. It's too easy to fall in the hands of underage folks. So let's do the math. For someone who's underage to purchase from a delivery service, they just need to find one person who will make an unethical choice. Whereas for an underage person to get it from a dispensary, they got to get through the security guards, whoever else is in the store, and the person who's making the sale. Oh, and it's on camera. So, I mean, just to me, that's a big difference in controls. And if we want to have controls on this, there's just a lot more controls on a storefront dispensary than there is on a delivery service.
Supervisor Wolf and Supervisor Adam.
Thank you, Madam Chair. And I was wondering if we could have Sergeant Olmsted from the Sheriff's Department maybe come up and talk about this issue of delivery versus a actual site. And I'm sorry to put you on the spot, although I know that you said you would be here to answer questions. But, we did have this discussion about the marijuana dispensaries, and there was a lot of concern at the site about safety, people loitering, and then there were folks who said that the delivery was better for a number of reasons. But I'm hearing both sides to this, so I'm just curious of what your opinion is. I think they're both bad. It's like, which one is worse?
Okay. Supervisor Wolf, through the chair. Supervisor Williams makes a lot of good points on just the safety and security of the differences between the storefronts and the delivery service. The storefronts would be a lot easier to regulate and manage for probably all purposes, including even tax enforcement and stuff like that. A lot of jurisdictions are requiring various things like ballistic glass for the storefronts, security systems, security guards, video cameras, different things like that. Actual brick buildings rather than metal buildings or something that could easily be cut through. The delivery services can be robbed easier. It's just the delivery service. You don't know what kind of quantities they're having as they're delivering out. So does a person go and they have 10 deliveries, so they carry enough for their 10 deliveries, or do they go back to wherever their home office is to get another delivery? So they're definitely a lot easier to rob. It doesn't mean that dispensaries haven't been robbed. They have been. A lot of agencies are having problems with that too. But in order to rob a dispensary, you're going to have to do a lot more stuff to gain access. It's a lot easier to get evidence for when we go in and later investigate the crime because it's going to be on camera. It's going to take them time to enter the business depending on how we ask the dispensaries to set up their security system.
I wasn't necessarily thinking along those lines, but maybe maybe we just don't do delivery. Or again, the interesting thing is that when you talk about the bulletproof glass and the security guards, and I see these at any little strip mall or something, I think, man, is that what we want? But it sounds like if we're going to have something, that if it's limited in number, then that's probably better than delivery.
That would be our recommendation right now. I mean, it's not going to eliminate any certain problems or crime. I mean, people are going to, it's no telling why people commit certain crimes, and they also commit crimes on the impossible too, and they get caught or different things like that. So it's not going to totally prevent it, but the more you can prevent it, the less likely you're going to have those problems.
Thank you. Can I also add the point about smoke or pot cafes or whatever?
No consumption.
No consumption. I'm voting no on that.
Supervisor Adam.
Yeah, the only thing I'm going to say, and I could go with you on the delivery service deal. That makes a lot of sense, and I get that. However, you are fighting technology, and there's all these. I was recently driving through San Francisco, and the buses have wraps advertising the various delivery services. I mean, there's a lot of that going on. So everybody doesn't get robbed for sure, because you wouldn't be able to get a driver if they did. So, it's Dennis. You want to say something?
Just Chair and members of the board, just so we're also clear on this. So under the statutes currently, delivery services, let's say that would be part of a retail licensee in the city, in any one of our incorporated cities, will still be able to utilize our county right-of-ways for the delivery services that are originating from a retail outlet within the city. So I just want to be clear that while this would certainly, if this conceptual direction follows through and becomes part of the ordinance, we would be helping Commander Olmsted with some of his problem, but maybe not all of the problem in that setting.
I think there is a good opportunity here. The state law that the voters just passed, in my view, was too permissive on some things, but it did basically try to move things away from the delivery service model by requiring that all of it be sold to a storefront dispensary. Now, people have figured out a way around that, which is to create a dispensary that doesn't have any customers, right? A dispensary that just sends out cars to deliver. But to me, that's getting around the intent of state law. The intent of state law is to try to wrangle this whole delivery service quandary. And, I'd remind folks that the reason why they exploded so much is because so many jurisdictions banned dispensaries. So that instead of having a few dispensaries move into your community, you had a dozen delivery services move into your community. And so to me, it's not perfect, but if there's at least market competition from the dispensaries, we can reduce the amount of deliveries.
Supervisor Adam.
Yeah, the other thing is, at some point somebody's going to put together a drone. Amazon wants to deliver things with drone, and you can get a pizza and you can get a fried chicken delivered to your house and Chinese food, and at some point you're going to be fighting the drone deliveries too. So, I think some of this is just, we're I'm trying to find a ranchy expression that's not too raunchy. Yeah, we're trying to keep the horse in the barn, and it won't stay. So, we can try, but I don't think we're going to get it done. And here's another question for either Dennis or Mr. Olmsted. What is the legality of, if there was the theoretical or maybe actual dispensary up in Rancho Napomo, can we keep him from delivering? If I get on the phone and say, bring me a fatty, can he, hey, I know a lot of words.
Look at the color of his tie. That ain't by mistake.
That's right. So can anybody prohibit deliveries from elsewhere?
I'm pretty sure they're going to be able to, because again, it's the public right-of-way issue, and they can't be restricted even by the county boundaries. But I think we ought to do a little bit more research on that. I always thought broadly about public right-of-ways being not necessarily different flavored types by county boundaries, but perhaps even Mr. Gazzoni.
Chair Hartman and Supervisors, there is a Business Supervision Code provision that says that the county cannot prevent the transportation of marijuana through its jurisdiction. So that's our starting point.
Okay, Mr. Bozanich, have we done our work today?
Oh, no, we just have to talk about mixed use.
So actually, it's an excellent point. So I did get opinions rendered from the 2nd District and the 4th District on mixed use, but I didn't know if any of the other supervisors wanted to weigh in on mixed use.
For which cultivation or sale or?
Currently, under the chart we have, it's simply for non-volatile extraction and retail.
And my thought is that we don't allow that in mixed use.
I'm not going to allow anything in the 2nd District, believe me. You're fine. If we just banned it in the 2nd, we'd be awesome.
Oh, stop. Did you see how many X's I have up there?
Will you vote for those X's, or do you just like putting them up there? That's what it comes down to. I don't think you're voting for the X's.
But you know why.
I know.
You know why.
And I respect your opinion, and I respect your position. I'm going to wait until I see more from the EIR on the mixed use. Okay? I'll leave it open for me.
I mean, for me, I'm open to changing my mind, but I would permit it for now. The reason is, if you guys want to take C1 and C2 out, the only C3, like, you should really look at the maps for the C3.
I'm the only one who wants C1 and C2 out. Oh, you are? I think.
I went with you too.
Oh, okay, good.
So that's my issue is if both C1 and C2 are out, then I think mixed use has to be in, because there's just nothing out there.
But it's the same rationale.
You're basically saying we can have it in one of 3 places. Literally,
there is something
if you
else.
Look at the map, C3, there's like 3 parcels in the whole damn county.
So this does, I mean, we are learning some things from other jurisdictions. When you do, and I know it's nice to be able to say, I don't want it here, and I don't want it there, and I don't want it there, and I don't want it here. You do drive up the price of what somebody's property is going to go through the freaking roof, because it happened in Grover Beach. Can't do it here, can't do it here. This is our little spot we want to do it in. And you end up basically giving somebody a lottery ticket, because that's the only place you can do it. So,
Well, and that is what most communities do, is that they do limit, or I didn't realize Santa Maria banned it. So it's
and
not.
it's still being done. It's banned, and there's 15 different apps that you can get to deliver to your house in Santa Maria, but it's banned. So
You know what's so interesting? I wasn't going to bring this up, but someone did talk about the New York Times article, and I'm not sure it's the same one, but I have a New York Times article. It just came out September 9th, and it says, despite the promise of legal marketplace, many growers are staying in the shadows, casting doubt on the promise of $1 billion tax windfall for the state and a smooth switch to a regulated market. So I don't think that what we're doing is going to be a panacea, but again, I think we should start from a place where we are taking control of our community, and we can always expand it later. I just feel so strongly about mixed use. The residential component, again, I say, if we're not allowing it in residential zones, why would we allow it right downstairs from someone where they're living? So I hope I get 2 more no mixed use votes.
Supervisor Williams, did you?
I would be persuadable, but if C1 and C2 aren't in, then you're essentially saying that there's by my count, 3 to 6 parcels of C3 in the entire county. So
Can I just say one thing, Das? I watched the Montecito Planning Commission, and do you know that there are they said, are there any areas here that we can have a dispensary? And the answer was no. I think there's one cultivation site. So, I think, I'm trying to be rational and reasonable, but if you really want it in all over, then we should have it in commercial, in neighborhood commercial. But we're not. And the reason we're not, it's because it's close to the residential areas. I'm not saying we should do it. I'm just saying let's be consistent. And this mixed use was thrown upon us when we did the Goleta Community Plan. It was never something that the community wanted, but we were told, as I read to you before, that it would be compatible with residential uses. And it would just be so misguided, I think, for us at this time to change course. And it's such a, I think it just flies in the face of good planning.
Supervisor Adam.
Yeah, I might have to back up on C2 because there is some C2 out there, and I'm looking at my orchid map here, and I don't see any. Is there any C3 in Santa Maria Orchid? Guys? Thank you. Let me get an official answer.
Yeah, I said no mixed use. I will. I'll go back to it. Yeah.
Yeah. So a little tiny Supervisor Adam through the chair. So Mr. Clemens identified a small little parcel just to the east of Winter Road in Orchid.
To the east of Winter Road.
Excuse me, west. Oh, there you go. That looks better. Yeah. West or east? West.
it's a little 20 by 20 foot, like.
So, Supervisor Adam, can you, given that can you make your point, and we're going to try to finish up here, give everybody one last comment? And
Well, I'm waffling on a C2.
Okay, well,
because if we're not, if we don't have any C3 or I don't know.
Yeah, let me add that, well, 3 things. This is all conceptual. We're not making any decisions, but we're giving some direction to staffs, and they can see where we need to know more. One of those areas is in distribution, and I would like to know more about what it means for the business, how much, if we outlaw it here and we're just getting it delivered from elsewhere, then I'm not sure what that means. I'm interested in having stuff that's easy to regulate out of the box. Supervisor Wolf asked me to emphasize, I also support not having it in mixed use, and if that means we need to broaden the commercial districts where it might be sold, I'm open to that. Did you have more to add, Mr. Gazzoni? Supervisor Lavanino.
Just in closing, Madam Chair, I just wanted to thank everybody that came today. It's you guys have been here for now 6 months worth of meetings. There'll be more, and both sides. I also want to thank, particularly I want to call out SEIU, because I think I'm always the one saying I want you here when we're talking about revenue, so I appreciate the fact that they were here today. And the other thing is, I'm fine relinquishing the ad hoc and much more planning commission involvement, but I also want that to be with the fact that they understand that we are on a timeline, and that the reason why the ad hoc, I think, worked was because we knew what we were up against, and sometimes through no fault of their own or whatever, when things go to the planning commission, things tend to get gummed up a little bit. So hopefully they understand what timeline we're on, and staff holds them to that timeline, because I think it's really important to be able to get as many people moved from, out of compliance to into compliance. So those are my concerns.
One last comment. I would just like to go back to the, I don't want to say buffer, the 1,000 feet. What's it called again?
Setback?
Not the sensitive receptors.
Oh,
That it be 1,000 feet, as noted from the health people, San Luis Obispo, other jurisdictions, and that it include preschool, elementary school, junior high school, library, park, playground, recreation or youth center, or drug recovery facility. And that's taken from San Luis Obispo. And I know we try and be consistent with our neighbors, so.
Oh, come on. Come on.
Well, okay, I'm trying to be
All right.
consistent with our neighbor Santa Maria.
Let's be consistent with everything San Luis Obispo does. I think we're going to
Well,
pick and
that
choose.
one,
That
anyway.
one works for you.
So Supervisor Lavanino, did you have one
Yeah,
last
I'm
comment?
just curious where we ended up, because we didn't put it up on the wall, so I'm kind of curious. I know people are going to be not just on the buffer. What did we, consensus?
Supervisor Lavanino, to the chair, I think there was a lot of qualifying comments about, particularly page 13 with the chart we have in front of us with the license types and the zones. I think it's going to take staff a little bit of time to come back and reorganize that and in a coherent fashion. Yeah, and I would suggest that we could bring that back as a small portion, a summary of what was discussed conceptually today, could come back as a small portion of the report on November 7th, along with the tax and finance information that we promised earlier.
For the moment. Okay, Mr. Cazzoni, was there anything you wanted to add?
Chair Hartman, only that if Supervisor Lavanino was looking to disband the short-term advisory ad hoc subcommittee, that could be part of the motion today, just for clarity.
Okay.
Yeah.
So
I
would
didn't
you-
have the rest. Yeah, let's add that as part of the recommended actions and receive the report. We provided our directions and the other two recommended actions as listed, along with disbanding the ad hoc subcommittee.
And may I have a second? Do we need a roll call vote, or can we just, all in favor, say aye? Any opposed? So this meeting is adjourned till October 3rd in Santa Barbara.
Introducing real-time bus tracking from Santa Barbara MTD. To improve your day, receive instant bus arrival information via text message. When you're at home, use your laptop to see exactly when your bus will arrive and spend more time doing what you love. Our mobile app will help you stay on schedule and focused on what matters most. Because when you're on the go, MTD will get you there. Real-time bus tracking, new technology that will change the way you ride with us. Available wherever you are.